much for that introduction. And it's a pleasure being with you and, sharing my knowledge. So we are here to discuss on this subject, multidisciplinary case studies. It is the third module in the professional course of CS, and it's the last paper, paper 8. So rightly so, I must say, that's because all your theoretical knowledge is put to test here. This is a practical subject where your theoretical knowledge is put to test. We may have knowledge of IBC, Companies Act, Sarfaesi, RDB Act, Criminal Procedure Code, IPC, probably all the other legislations, could be SEBI, FEMA, but how it generally, how is it that you actually bring it down to the ground level? Probably how is it that it operates at the field level becomes important. That is very important both for PCS and CS in employment. Now, PCS is required to know this because he should know how the whole the litigation would take a turn, or how a proceeding could be a proceeding for amalgamation, demerger, or probably reconstruction, whatever, how it would take and what are the case laws, how the law applies. Probably a study of this subject actually also says how the law has evolved, how the law evolves. And for a company secretary in employment, it is very important to know the various legislations, the way the courts interpret the law, the hierarchy of courts, the tribunals, the forums, the courts which you are required to approach, and the manner or the sort of relief that is given. And we must also know where we wouldn't get a relief. And there are certain circumstances where you may have appeal provisions, but you still can approach the High Court in a writ petition and obtain a relief. So these are some of the things that are actually brought out in this case study. And basically, you can see an interplay of the laws. You have Sarfaesi Act, you have DRT Act, and you have Arbitration Act, and you have IBC Act. Now, which prevails over which provision, which act? So the question that probably could crop up is which legislation prevails over and which supersedes the other legislations. Now, this becomes important. And to what extent which legislation supersedes is to be understood. And I must say it's an open book exam. So I would advise the students not to go and open the books for the first time in the exam hall. Please go through the syllabus, go through the case studies given in the material. And very quickly, I would just tell you how the case laws have been structured, case studies have been structured in the study material. You have the case, the name of the parties, the nominal index, the name of the parties, A versus B. This is a nominal index. Now, probably you could have Mobilox Innovations Private Limited versus Kirusa Software Private Limited. This is the name of the parties. Then ideally, we have something called the citation, AAR 2019. 2019 is the year. SC is the Supreme Court, page number so-and-so. So this gives us the access to the respective journal to get the case law for further and detailed study of the entire judgment that is actually captured or that is actually dictated by the judges. Then you have the judges, whether it is you have the forum which is given the judgment. Probably if you have the study material with you, you could please open the case law. You could open any page and you would see this is the manner in which they have actually brought out the case law. Then to the right, you have the forum, could be the NCLT, NCLT, or the Supreme Court, or any other forum, SAT, or SEBI, or whichever forum. And then you have the gist of the case, the facts of the case issue that is decided, and the reason. So this is how it is developed. And this is how you are expected to do in your exam. You are expected to, probably, I would say, if you are given a question, it is better you capture the facts in a precise manner, bring out the legislation, bring out the applicable laws. Probably if you know of any case law which is holding the field, mention the case law if you remember. If you do not remember, please mention in a decided case law, or if it's a celebrated case law like Swiss ribbons, you can say in a celebrated case law. If you remember the case law, please say, mention the case law, and then say what is laid down in the case and how the facts of this case become applicable to the how the law becomes applicable to the facts that are given in the instant case, and then give your reply. So this is how you must sequentially develop your answer to the question. From what I see, the first question is a 40-mark question where you're required to analyze and understand the entire problem, give your analysis, the facts, the law applicable, and the answer. Probably you have subdivisions in terms of questions, but this is the exercise that you're required to do. It's a 40-mark question, and then the remaining questions are 12 marks where you have small problems given to you, practical problems, and you're required to apply your mind, apply the law to the facts, and then give your reply. Now, of course, to some extent, or I must say to a great extent, common sense would work here because you have the support of the books. So you would be required to carry all the legislations indicated, the SEBI Act, the FEMA, the Companies Act, IBC. These are the, and I must say the provisions of, you must carry the Limitation Act. I think probably any other laws that you feel appropriate could also be carried, because you look at the gamut, it's quite wide. So you should carry the bare acts that would help you to at least analyze the provisions in case there is a doubt when you are writing the exam. Now, quickly getting into the subject. Now, basically, when you look at the syllabus or when you look at the chapters, you look at the case laws, you must first understand the concept of precedence. There is something called the law of precedence, where the decision of the Supreme Court prevails over all other courts in the country. The decision of the High Court prevails over all the subordinate courts in that respective state. So this is the law of precedence, which is laid down in Article 141 of the Constitution of India. So this is something that we have to understand. And why is it that we have the law of precedence? To ensure that the settled law is not disturbed and there is consistency in the judgments of the various forums and courts. Now, it shouldn't be a proposition where you are not very sure what would be the reply, what would be your, what would be the outcome. So it is very important that there is consistency, and it's very important that the settled position of law is not disturbed. So that is the reason why you have precedence. Now, for instance, let me take an example of a situation where a person approaches the NCLT, the National Company Law Tribunal, and he is not given a hearing. And on the date given, without giving him an opportunity of filing his objections, the NCLT passes an order and he is aggrieved by this said order. Now, he can approach the High Court on a writ petition under Article 226 and 227 of the Constitution of India and challenge the order on the ground that it violates the principles of natural justice. So such a writ petition is entertained and the order is stayed. So here is a situation where you can approach the writ petition, you can approach the High Court instead of approaching the NCLT, that is National Company Law Appellate Tribunal, which is provided for under the Companies Act or the IBC. So here is a situation where the law does not provide. You look at the IBC or you look at the Companies Act, there is nothing which says that you can go to the High Court or the Supreme Court. But this is the law that becomes applicable given the situation that there is a violation of principles of natural justice. So when there is a violation of principles of natural justice, you can approach the High Court. Now, probably you would have observed Alok introducing me while in the introduction, he was mentioning about the 164(2)A petitions that were filed before the High Court. We had filed quite a lot of writ petitions challenging the disqualification of directors under section 164(2)A, where a director is disqualified for not filing, for the company not filing the annual returns or the balance sheets for 3 consecutive years. So if a company does not file, if a person is a director in that defaulting company, he is disqualified from becoming a director in any other company. So this provision was challenged. Now, I would not be able to challenge this provision before the NCLT. But however, I can challenge the wires, that is the constitutional validity of this particular provision before the High Court. And I would also be in a position to challenge the justiciability of the particular provision. So in such situations, I can approach the High Court and not approach the NCLT, because the NCLT would not have the powers to entertain if you were to challenge the very provision under which you are aggrieved. So I would prefer, refer to a case law here, Whirlpool Corporation versus Registrar of Trademarks. Though it is a settled position that the High Court would not interfere in a writ petition when there is an alternative remedy available. In certain circumstances, there are 3 circumstances under which the High Court would entertain a writ petition, and they are when it is in violation of the principles of natural justice, when it is when there is a situation where the provision of the legislation or the provision itself is challenged, or the constitutional validity is challenged, or where the order of proceeding is without jurisdiction, or the wires of the act is challenged. Or the third situation is where the fundamental right is violated. In these three situations, when the fundamental right is violated, when the very provision is challenged, and when there is breach of principles of natural justice, in such situations, we can approach the High Court and a writ petition, though there could be an alternative remedy of going on an appeal. Now, in fact, I said if there is we are all aware of the fact that when there is a breach of fundamental right, now let us say a person arrests by holding himself out to be a police, and he probably arrests the person and keeps him in his custody. You can approach the High Court in a writ of habeas corpus. Now, this is a writ petition that is available. Now, an example closer home. Now, let us say if a suit is filed for allotment of shares, or for shares not being allotted, or probably if a suit is filed for oppression and mismanagement, or for any remedies in respect of a shareholder's agreement, which probably should be challenged or agitated before the NCLT. In such a situation, we can file a writ petition before the High Court under Article 226 and 227, challenging the order of the civil court which is hearing the matter. Or we could also file a writ of certiorari, seeking for a relief that it should not hear the matter. Or writ of, if an order is passed, we file a writ of certiorari. If the matter is being heard, we would prefer a writ of prohibition, seeking for a direction that the court should not hear a matter which, in respect of which it does not have the jurisdiction. So these are the different situations in which a writ petition may be preferred. Now, the reason I wanted to address this issue in detail was because I have seen many company secretaries asking, how is it that you can approach the High Court when the enactment provides an appeal? So absolutely. So that is why, in order to ensure that you're not taken by surprise, you have this material, this subject, to understand the circumstances and situations in which a writ petition can be maintained by the High Court, in spite of there being an alternative remedy of appeal. Now, the next question that could probably arise is, to which High Court can a writ petition be filed? Now, I'll give you a small instance. Now, you have the state of Bihar. State of Bihar does not have an NCLT there. You have the state of West Bengal, the Calcutta bench, which has the Calcutta bench of the NCLT. The state of Jharkhand does not have NCLT bench. Now, let us say there is a matter which goes from Bihar. And let us say there is a decision given by the NCLT, Kolkata. Now, a person who is aggrieved by the order, let us say it is in violation of the principles of natural justice. To which High Court can he refer the matter to? before which High Court he can file a writ petition. Is it before the High Court of Calcutta? Is it before the High Court of Bihar? Now, let us say there is an order passed by the NCLT Bangalore, and I would want to prefer a writ petition from that said order. I would have no doubts because I can prefer it to the Karnataka High Court in Bangalore. But in a situation where you have the, in the example that I gave in the state of Bihar, you have the High Court in Patna. So you can prefer a writ petition to the before the High Court of Patna. The Patna High Court would have the jurisdiction to entertain, because the jurisdiction vests in the High Court, and by virtue of Article 226 and 227, superintendent's powers would vest with the High Court of that respective state. So in respect of matters which are decided by the High Court, by the NCLT, in respect of matters from Bihar, the Bihar High Court would have the jurisdiction in a writ petition. Now, actually, this is laid down in L. Chandrakumar's case clearly with respect to jurisdiction. Now, there is there are many situations where it is possible to cut short a long drawn criminal prosecution under the Companies Act by approaching the High Court and getting it quashed under section 482 of the Criminal Procedure Code. For instance, you have, let us say, you have prosecutions under section 452 for withholding of property belonging to a company. Or let us say there is a prosecution under section 166 of the Companies Act in respect of duties of a director. Now, let us say a director has committed an act which conflicts with his duty as a director. Generally, when we say duty of a director, it is a fiduciary duty. He acts in his capacity as a trustee. He acts in his fiduciary capacity. Now, this is the gist of section 166. And if this is violated, the punishment is provided for in under section 166, which relates to fine penalty. Now, probably you also have situations where you could sue a person under section 447 of the Companies Act for fraud. But however, there it is not possible for a person to initiate prosecution. A shareholder cannot initiate prosecution. It is only the SFIO, the Serious Fraud Investigation Office, that can initiate prosecution. So probably the central government can give directions to the SFIO to investigate into the matter, and SFIO can investigate and file a charge sheet against the company and the other accused persons. Now, it becomes a little important to understand the general provisions of Companies Act vis-a-vis the criminal law. Now, if you generally look at criminal law, it is very important for us to know whether an offense is cognizable, whether an offense is compoundable, whether an offense is bailable or non-bailable. Now, I'm sure we have studied all these in our study materials at various places, but to have a quick understanding, I'll just tell you what is a cognizable offense. A cognizable offense is that offense which a police officer can arrest without a warrant. If an offense is cognizable, it means that the person can be arrested without a warrant by a police officer. For instance, let us say there is an attempt to murder, or let us say there is a theft, and the person is traced by the police. The police can immediately arrest him. There is no necessity for a warrant. So that is a cognizable offense. So he can immediately arrest him. Now, are offenses under the Companies Act cognizable? The answer is no. Now, if you look at the offenses under the Companies Act, all offenses are non-cognizable. In other words, it has to be instituted by way of a private complaint report. When we say complaint, generally a complaint given before a jurisdictional magistrate having the power to entertain and adjudicate the matter. So the complaint is required to be filed. Now, I would draw your attention to section 439 of the Companies Act, which deals with the aspect relating to the person, the capacity of the person who can initiate criminal prosecution against any accused. Now, a person could be, a person is required to be a director of a company. a person is required to be a shareholder of a company in order to initiate prosecution under the Companies Act. Section 439 requires that a person who initiates prosecution by filing a complaint be a shareholder of a company. So a shareholder can initiate a complaint by filing a written submission before the jurisdictional magistrate, and the jurisdictional magistrate can then decide how to take it forward. Now, let us say for some reason, there is a situation where a complaint is initiated without proper procedure being followed. In such a situation, the High Court can be approached under Section 482 of the CRPC, and the matter can be quashed. Now, the example that is given in the study material, and probably I could also see some of the case laws being referred or being asked for, or probably questioned in the question paper, which relates to quashing of proceedings. Now, of course, I do understand that this 482 petition has not been discussed, but however, if I probably draw or recollect your attention, probably in your executive course, you must have studied about CRPC, CPC, and all the other provisions of law, other subjects of law. Now, a situation where a person is prosecuted for an offense which cannot sustain, can be dismissed or quashed by the High Court without a detailed trial being ventured into. Now, how does a criminal prosecution generally go on? Now, initially, there has to be an investigation by the SFIO. Let us say there is an offense under Section 447 fraud. After the investigation, the SFIO, the Serious Fraud Investigation Office, files its charge sheet. Based on the charge sheet, the special officer, the special court is constituted under Section 435 of the Companies Act. There are two types of special courts. One is the Sessions Court, which is the court which can try matters in respect of offences punishable with imprisonment for more than 2 years. And then you have another special court, which is a magistrate court, which tries offences in respect of which you have punishment less than 2 years. So you have special court in the magistrate court. Of course, in Bangalore we call it the special court for economic offences, and that is the magistrate court. And then we have the special court in the sessions jurisdiction, which tries offences in respect to which punishment is more than 2 years. So in such situations, what happens is, now let us say we were talking about Section 447, a report is filed by the SFIO. The SFIO, the report that is filed is generally called as charge sheet. Based on the charge sheet, summons is issued to the accused. In one of the cases, in Bhushan Steel matter, summons was issued to a nominee director on the ground that he is, in view of the fact that he was also one of the accused. That was challenged before the High Court under Section 482, and that was quashed. The summons and the prosecution proceeding as against the said director, nominee director, was quashed on the ground that there is no specific allegation as against the director, and that the director, the nominee director, is not duty bound to find out the inner details and dig into it and then take steps to prevent the occurrence of the crime. The point is, he is not an accomplice. He is not a party to the crime, and such being the case, the report as against him has to be quashed, and it was quashed. So Section 482 CRPC deals with inherent powers of the High Court. This power does not vest in the Magistrate Court or in the Sessions Court. It only vests in the High Court. Now, but for this quashing, in fact, I must pause here for a moment to say, people generally use the word squash. That is not squash, it is quashing. Quash. So, in a circumstance where, let us say, the matter had not been quashed, the nominee director would have had to stand the entire trial. He would have had to appear on every date of hearing. He would have had to cross-examine the prosecution witnesses to show that he is not involved. Then he was required to answer the 313 statement to say that the judge would pose a question: are you guilty? Do you agree that you are guilty of the charges alleged against you? And then the matter has to be heard, and then the judgment would be passed by the sessions judge or the special court. Now, just imagine this whole process is such a lengthy process, and of course, though it is lengthy because it's a sessions court, it is done as quickly as possible, but nevertheless, it takes a lot of effort and time. This entire process is cut short and he is acquitted, or probably he is dropped by virtue of a quashing, by virtue of an order of quashing by the High Court, and the entire process is, he is saved of the entire time and effort that he would have had to otherwise undergo. So here, if on the face of it, from the complaint or from the charge sheet, it can be made out that a person is not would not be convicted, or that the overt act insofar as that accused is not brought out, in such circumstances, the High Court would quash the petition, the complaint, using its inherent powers. There are circumstances where the complaint would indicate the lack of bona fides as against the accused. In such situations also, the High Court exercises its powers under Section 482, using its inherent powers. So these are some of the instances that you can probably keep in mind and answer questions if you get. And I was in fact mentioning about bailable offenses, cognizable and non-cognizable. Now, the next point is, next aspect is bailable or non-bailable offenses. Now, for the most part, the offenses under the Companies Act are all bailable. Bailable is offense is an offense where, as a matter of right, the accused can approach the court and ask for a bail to be granted, and the court is bound to grant bail. Now, there is another situation which deals with non-bailable offenses. Now, probably non-bailable offenses could be wrongly misunderstood to mean that bail is not granted. But that is not the way. It is that bail would not be granted as a matter of right. You are required to convince the magistrate or the sessions court that here is a situation where there is a bona fide on the part of the accused, and that the offences alleged against him do not stand, and that he is innocent of the offences alleged, and that he is ready to stand or furnish guarantee or surety for the purpose of him appearing on every date of hearing. And there is no possibility of he absconding from the jurisdiction of the court. In such situations, bail is granted even though the offense is a non-bailable offense. So looking at Companies Act, as I said, most of the offenses are bailable offenses, except certain offenses like Section 447, which relates to fraud, 447, 448. Those offenses which are more than, generally you have a classification which lays down offenses which are bailable and non-bailable. But however, we don't have a classification insofar as Companies Act is concerned. Most of them are bailable, and Section 447 is non-bailable. When I say non-bailable, offenses which are punishable or probably punishable with imprisonment of more than 7 years is non-bailable. Now, here is a situation where 447 is punishable with an imprisonment of 10 years, up to 10 years. In such situation, it becomes a non-bailable offense, and the requirements of 437, that is, the requirements of a non-bailable offense are to be followed for the purpose of getting the person released. And you must also know that there is a provision for anticipatory bail. In a situation where you know that one of the directors could be arrested, or probably a professional, a PCS or a CS in employment could be arrested. There have been occasions where we have ourselves got anticipatory bail for some of the professionals. In such situations, you must be alert to ensure that anticipatory bails are obtained for the directors or professionals. Unfortunately, let us understand that when the litigation goes to an extent where the parties stoop to any level, they don't spare the professionals. They, file false complaints against the professionals, the company secretaries, chartered accountants, statutory auditors. They don't spare anyone. We have had occasions where non-bailable warrants have been issued, and we have moved and obtained anticipatory bails. Now, for the purpose of moving an anticipatory bail, it is most important that you know that an anticipatory bail is granted only for a non-bailable offence. If an offence is bailable, the question of granting anticipatory bail does not arise. For the purpose of understanding which offences are non-bailable and bailable under the IPs, as I said, Companies Act, you know which offence is non-bailable. Now, under the IPC, Indian Penal Code, now let us say there are certain provisions which become non-bailable, and it would be necessary for you to obtain an anticipatory bail. You must see schedule to the CRPC, which gives you the breakup of which offence is bailable, non-bailable, compoundable, non-compoundable, and cognizable, non-cognizable. Now, what happens for the most part is when an offence is, when a charge sheet is filed or when a complaint is given, it's a mixture of offences under IPC and Companies Act. So, even in such, if there is a mixture of offences, the special court would have the power to entertain. In such situations, we should still know the provisions which are bailable and non-bailable. And the last point to which we come relates to compoundable offences. Now, if you look at the schedule, and I must also say you can refer to section 320 of the CRPC, which deals with these classifications. When I come to compoundable offences under Companies Act, I must say most of them are compoundable, and you have section 441, which is further amended now. So you can approach the RD for the purpose of compounding the offences. So this is the general aspect relating to criminal prosecution, and which relates to the reliefs and remedies that are available under various procedural laws. Now, when we talk of some law, we should first understand whether it is a procedural law or a substantive law. Now, for instance, when we talk about prosecution, when we say that a person is charged for fraud under section 420 or cheating under section 420, we should understand that 420, which is referred to, relates to IPC, Indian Penal Code. Now, that is a substantive law. The substantive law here is IPC. Which is the procedural law? The CRPC, the Criminal Procedure Code. Now, when I say a person is charged under section 447 of the Companies Act, the substantive law is the Companies Act. The procedural law is a Criminal Procedure Code. Let us understand for all the laws, for most, I must say, for most of the laws, except some special legislations which deviate, it is a CRPC which is a procedural law. Now, there are some deviations in certain penal provisions in certain laws. For instance, there are certain laws like NDPS, Narcotic Drugs and Psychotropic Substances Act. Now, let us understand the principles. Now, in any criminal law, generally, a person is presumed to be innocent till he is proved to be guilty. But you look at special legislations like NDPS, let us say, various other special legislations, the person is deemed to be guilty unless proven innocent. So that is the PMLA, Prevention of Money Laundering Act. So all these, so you must know the difference. So when you look at a particular legislation, you must understand to what extent there is a deviation. Now, why should you know all these? Only then it becomes easy for you to analyze. Now, you may say it's a job of an advocate, but I must say, as a company secretary, whether PCS or a company secretary in employment, these details become very important and very relevant for you to take a call given the situation. So it becomes very important to know all these. Now, from criminal prosecution, let's jump to civil litigations. We have section 430 of the Companies Act, which says civil courts cannot try matters in respect of which NCLT alone has a jurisdiction. When I say that, if there is a litigation between shareholders under operation mismanagement under section 241, 242, such a dispute cannot be entertained by the civil court. Now, if such a litigation is entertained by a civil court, as I said, you could approach the High Court in a writ petition and get the proceeding quashed under a writ of certiorari. In fact, we have 5 writs, which I'm sure we all would have learned. Now, in such a situation, we can get the proceeding quashed. Now, going further, now if there is a situation where there is a petition filed before the NCLT by a director challenging that he has been issued a notice for being removed from the directorship of the company. The question is, would the NCLT entertain his petition? Now, these sort of questions are asked to test your knowledge and understanding of the principles of the Companies Act. And you have such similar questions. Now, coming back to the question that I posed, the answer is that the NCLT will not grant any relief to a person who approaches the NCLT in the capacity as a director, alleging that he is being removed from the directorship. Because the relief that is granted by the NCLT, or the relief that is contemplated under section 241, 242 of the Companies Act 2013 only is in respect of dispute between or among shareholders, qua shareholders. In the sense, when I use the word qua, in their capacity as shareholders, it should be a dispute in their capacity as shareholders. Now, for instance, if I give a situation where a person approaches the National Company Law Tribunal alleging that he is a shareholder holding the requisite number of shares for the purpose of filing a petition under section 241, 242, and then states that the company is a private limited company which was promoted by him, which is a quasi-partnership, in the sense it's a family-run business, or probably it's a business which started off as a partnership, 2 partners, and then it became a company. There are only 2 directors, and this person is one of the directors, and which the other person is trying to throw out by virtue of the fact that the other person has, let us say, 60% shares. Now the other person is moving the EGM, the extraordinary general meeting, is calling for an EGM for the purpose of appointing another director and then removing this person from the position as a director. Now, this is clearly communicated and actions have been initiated, notices have been dispatched. Now, if this person who is sought to be removed from the directorship of the company approaches the NCLT, would he get the relief? The answer in all probability is yes, he would get the relief, because his rights as a shareholder, that is qua shareholder, in his capacity as a shareholder, is being affected. So for the purpose of proving that there is oppression, it is required to prove or show to the tribunal that the acts are burdensome, are harsh, are... I see some of the questions coming. I'm happy to see some questions coming. If the petitioners are in a position to, if the petitioner is in a position to prove that the respondent is targeting him for removing him from the directorship, and the actions are harsh, burdensome, unfair, in such situations, even if the respondent follows the law, even in such situation, even if the respondent or the other shareholders or the other director follows the procedure laid down under the law for removal of this director, still it would amount to an oppression, and the NCLT would have the power to stay such a removal. So what is important here is, even if the compliance of the procedure required is done, if the act is oppressive, the NCLT would give a stay. So it is required that we look at the whole gamut, understand the facts properly, and then give our reply. Now, in a situation, in fact, I was looking at some of the case laws given in the study material. it is very much important for you to understand the facts. You may probably have read a question in your study material, and there is one small twist in the case that is given in the exam. Your entire answer would differ. So please understand the case that is given to you in the exam before you put your pen on the paper. Analyze, is it the same law that is explained in the book that becomes applicable here? Because one twist and the entire case changes. So in the first instance, I said the person who approached the NCLT was a director, and he was only challenging the action of his being removed from his directorship. The answer is the NCLT will throw him out. But in the second instance, I said he is a director, but he's also a shareholder, and that he is a person who's a founder member, or he was a partner which founded the partnership, which later on converted into a company, or probably he's a promoter director, or that the purpose of removal is to ensure that he is just thrown out and sidelined so that the other director and shareholder takes it all. Now, if there is one more aspect, for the most part, if the management is so intertwined with the shareholding, the NCLT would entertain your petition, though the dispute may apparently seem to be at the level of management. Now, probably you have a shareholders agreement. You also see a lot of litigation coming up on account of some disputes arising from shareholders agreement. When there is a shareholders agreement and there is a breach of the shareholders agreement, or probably there is a situation where one person wants to ensure that it is breached. In such situations, circumstances are created to approach the NCLT, and the reliefs are sought before the NCLT to undo the shareholders agreement. Now, if you look at section 242 of the Companies Act, the NCLT has wide powers. You think of it and you feel this is the right remedy given the problem, the NCLT has the power to grant you. Only that you're required to convince that you are entitled for the remedy, and that is the appropriate remedy given the problem. So you have to probably think on the facts of the case, think on the lines of which would be the appropriate remedy, and ensure that you put your case before the tribunal. So here, what sort of disputes could be raised before the NCLT? Now, in fact, I was, so probably the questions could be of this nature, where you are asked to decide if the NCLT has the power to give the relief. So depending upon the facts, you'll have to see if the NCLT has the jurisdiction and the power to grant the relief. Now, let me give you another. Now, all the explanations that I am giving are from and in and out of your study material. And please understand that whatever I'm sharing with you could come as any small point could come out as an example, as a problem for you in your examination. So please be with me completely. Try to understand the concepts fully. I think I'll come back to those questions a little later. Before I jump on to the next topic, I'll come back to those questions. Shareholders agreement vis-a-vis the articles. I'll come back to them. Now, so every example that I'm giving is from the is very much relevant for the purposes of your exams and could appear as questions. Now, I am trying to share the concepts with you, because what happens is it would be very monotonous if I take the question and then give you the answer. So I'm just giving the concepts. Please get the concepts, and then you will be in a position to answer. You are required to apply your mind, be calm in the exam, apply your mind to the problem, and you will have the answer. Now, what sort of remedies the NCLT will not be in a position to grant? Now, before I look at that, I'll just share an example, or probably I'll discuss with you a particular provision of the Companies Act. You have section 72, which deals with nomination of shareholders. Nominee, you are required, every shareholder is required to give a nomination in the form. And once the nomination is done, that person, that nominee, takes over the shares as the owner, irrespective of the will irrespective of the testamentary disposition or the intestate disposition. Now, the position is, let me give you an example apart from the Companies Act. This is very important actually in our practical exposure to law. When you look at a banking transaction, if a person gives a nominee, a bank holder nominates a person as his nominee, that person is the receiver. That is, that person receives the money after the demise of the account holder. He is only the receiving hand, but the money is to be distributed in accordance with the bequest if there is a will, or in accordance with inheritance, depending upon the personal loss. So his hand is only the hand that receives the money. He cannot take it. But under the Companies Act, if you look at section 72, subsection 3, a nominee is a person who takes it, irrespective of the testamentary or intestate disposition. So, even if a will is written, the person who is the nominee takes it, and he has to be brought in as a shareholder, and the shares have to be transferred to his name, provided the nomination is done and is perfectly in order. Now, if there is a dispute with respect to the disposition, now let us say there is a will. By virtue of the will, Mr. X gets the shares. By virtue of the nomination in the company, Mr. A gets the shares. Now, the person who gets it by way of the will approaches the NCLT and says, please see that I get this share, I get these shares. Allot the shares in my name. Section 59, rectify the register of members. So he files a petition under section 59. In this out of the example illustration, or probably one of the case laws that is given in the material. And a section 241 petition is filed. The question is, can the NCLT entertain this? The answer is no. It is only the civil court which can entertain these sort of disputes which relate to testamentary or intestate disposition. Now let us quickly understand how the proceedings happen in the NCLT. In the NCLT, the petitioner who approaches the tribunal files the petition. He brings out all the facts. He brings out what has gone wrong, what are the injustices met to me, and what is the law on the point. And then he says what is the remedy he asks for, grounds and the reliefs, facts, grounds, reliefs. And then the respondent is summoned. He is permitted to file his objections. He files a statement of objections. Subsequent to that, the matter is posted for hearing. Based on the documents, statement of objections, petition documents, the matter is heard. Probably the petitioner may have the right to file his rejoinder. If he files his rejoinder, that also becomes a part of the pleadings. We strictly don't call it pleadings in terms of the CPC, but nevertheless, it is come in terms of usage. Based on the pleadings, the matter is heard and the order is passed by the NCLT. So you have the petition, statement of objections, rejoinder, along with all the documents filed, and the matter is heard by the NCLT and the order is passed by the NCLT. Now you look at what happens in a civil court. In a civil court, a plaint is filed. The defendant, in a civil court, we call the parties as plaintiff and defendant. But in all other courts, all other jurisdictions, you call them petitioner respondent. It could be High Court, petitioner respondent. It could be NCLT, petitioner respondent. It could be any other forum, it is petitioner respondent. But in a civil court, where you have the trial jurisdiction, the original jurisdiction, we call the parties as plaintiff and defendant. So the plaintiff approaches the civil court. Let us say in a situation in the example that I gave, he approaches the civil court, files a suit for challenging the nomination that is done in the company and says that he has to be allotted those shares. He files and he says declare the will. He asks for a declaration that the will is valid, and probably he asks for probate of the will, and then he says that the shares be transferred to me, or I am entitled to 1/4 share or 1/3 share or half share, whatever, depending upon his claims in the probate and succession certificate proceedings or the original suit. Now, in the original suit, the defendant appears and files his written statement. Written statement is a statement of defense. Then the the court drafts something called issues. Issues are statements of dispute between the parties. Now, there are certain facts which are admitted. Mr. A and X are related. That is admitted. Mr. Z was the propositor, or he was the person who's written a will, or he has nominated. That is not in dispute. So he's the person. So there are certain admitted facts, certain facts that are disputed. So insofar as facts that are disputed, issues are drawn by the civil court. Issues are questions which are required to be answered by the plaintiffs or the defendant, depending on whom the burden is cast on. For instance, the questions or the issues could be, does the plaintiff prove that he got the will much later, he found the will much later after the demise of his father? Does the plaintiff prove that the will is genuine? Does the plaintiff prove that he is entitled to 1/2 share, or the claim that he makes to the property? Does the defendant prove that the will is fabricated? So you have it very clear as to who has to prove which issue. Does the defendant prove that the nomination is valid? Does the what order or what relief? So these are issues. Now, based on the issues, the plaintiff has to lead his evidence, get into the witness box, lead evidence. We have affidavit evidence filed, and then the defendant cross-examines. For the most part, it is the advocate for the defendant who cross-examines the plaintiff witness. He could have more than one witness. And then after that, you have the defendant's evidence. Defendant files his affidavit evidence, gets into the witness box. The plaintiff counsel cross-examines him. And then you have the arguments on the main case, and then you have the judgment. So what comes out finally after the entire trial is called a judgment. What comes out after the petition, objection, rejoinder is called an order. So this is the basic difference between a judgment and an order. Now, for instance, having said this, I must also draw your attention to something called interlocutory application, where again, it is done just like a petition. So what happens is, now we had this suit filed. Now, the plaintiff may have the apprehension that the nominee may sell the shares. The nominee has got his name registered in the register of members in the company. So he's already become the member. Now the plaintiff says that I have got it by virtue of the will. So he now has the apprehension that the defendant, who is the nominee, may sell the shares. So he may file an application in the civil court telling, that is in the suit. There is a suit for any interlocutory application or an interim application to be filed. There has to be a suit pending. Only in the suit you can file an application. That is an interim application. An interim application is filed by the plaintiff seeking for a relief that the defendant be restrained from alienating or selling the shares that have been nominated and transferred to his name. To that application, the defendant is required to file his objection statement. And then the application, objection statement, and the procedure is you file the application, the objection statement, and then the court hears the application. After the court hears the application, an order is passed. So what comes out of an interim application is an order. What comes out of the trial of the entire case, you have the plaint, you have the written statement, issues, evidence, arguments on the main, and then you have the judgment. So this is the difference between an order and a judgment. What comes out of the NCLT is an order. What comes out of the High Court in a writ petition is an order. What comes out of a civil court after trial is a judgment. So these differences are required to be borne in mind, because as a professional, you cannot use it interchangeably. You cannot say judgment in place of order. You cannot say order in place of judgment. And when you go before the NCLT, when you say a judgment, it very clearly indicates that there is some civil case and you're referring to a judgment in that civil case. If there is an order, I, as a judge, would think that you are referring to some interlocutory order either here or there. Now, there could be situations where you could also have miscellaneous applications, MA, or applications like how we file under Section 7 of the Insolvency and Bankruptcy Code 2016. Now, that is a separate proceeding by itself. So there, it's not an interlocutory application, but an application by itself, which you could call an application under Section 7, Section 7 application, Section 9 application, Section 10 application. So these are applications under the relevant statutes. So having said this, so we must also understand that there are certain limitations that the NCLT would have. It may not be in a position to try certain cases when it is restricted specifically under some legislation, but for which generally under Section 430, the civil court is specifically barred from trying those disputes or litigations which the NCLT would have the jurisdiction. Now, we have Section 252. Section 252 deals with restoration of companies which have been struck off. Now, ideally, if you look at it, it's an appeal. The provision refers this as an appeal. Now, if, let us say there is a company whose name has been struck off under Section 248 of the Companies Act, the remedy that the company would have, or the directors or the shareholders would have, is to approach the NCLT by way of appeal under Section 252, file an application, justify why the company did not respond, or whether the company was actually running its business during the period when the notices were sent and not received and not responded to. Now, what the ROC generally follows a procedure of sending notices 3 times and the company does not respond or it gets returned back. The ROC presumes that it has stopped running business, it stopped its operations, and then would strike off the company. In a situation where the company wants to restore, there could be a situation where there is the change of registered office without intimation, or there could be a situation where due to genuine reasons the post has got returned, or there could be a situation where the returns or balance sheets have not been filed for some reason, or for some reason the company is unable to file its returns and take things forward on account of internal disputes. In such situations, it is required to communicate the reason as to why the company should not be struck off in the notice that is sent by the ROC. But let us say for some reason it is struck off, you can appeal under Section 252, justify why the name has to be restored, and then there are 3 grounds on which a restoration can be sought for, where the company was actually running its business, but for various reasons it could not respond or it missed out, genuine reasons. And second, where the name is required and it has the intention of running the business and it has the capacity to run the business. Third situation, where there are assets and liabilities and the company is capable of running its business, and as such it is required to be restored for the purpose of revival of the company. So these are the 3 circumstances, and of course if there are other genuine reasons it can be entertained, but these are the general 3 circumstances under which the name can be restored back to the register of the ROC. If I may now look at the questions.
Yes, sir. I will just read out the questions. So the first one is Padma. She says, offenses under Companies Act may be cognizable or non-cognizable depending upon the intensity of the offense.
Correct. As I said, under Section 440, they're all non-cognizable. Non-cognizable. So that's where I said all offenses are non-cognizable. If you look at Section 436 of the Companies Act, I'll just 439 of the Companies Act. I would just read subsection 1. Notwithstanding anything contained in the Code of Criminal Procedure 1973, every offence under this Act, except the offence referred to in subsection 6 of Section 212, shall be deemed to be non-cognizable within the meaning of the said code. So all offences are non-cognizable except Section 212(6). That is, now let us say there is a situation, I said 437. If a complaint, Section 212 subsection 6 refers to Section 447. Or a situation 212(6). So most of the offences are non-cognizable except the offense referred to under section 212 subsection 6. Now, let me just draw your, refresh your memory. If there is a situation where the central government directs the SFIO, Serious Fraud Investigation Office, to investigate into a particular offense. Now, let us say you have Satyam. Now, the central government directs the SFIO to investigate into it. The SFIO has the power to arrest the person. So, except 447, generally all other provisions are non-cognizable. Yeah, I'll just read out subsection 6. Notwithstanding subsection 6 of section 212, notwithstanding anything contained in the CRPC, offense covered under section 447 of this act shall be cognizable, and no person accused of any offense under those sections shall be released on bail. Anyway, that follows so 447 is cognizable, and the investigation authority would not be the police, it would be the SFIO. Under the CRPC, IPC, the investigating authority would be the police. So this is, I think, clarification which I hope has clarified the position.
Yes, sir. Sir, there's one more question. Sumadhi says, in a case of shareholder agreement.
In this context, will NCLT give relief? No, it is a criminal prosecution. NCLT has nothing to do with that, with criminal prosecution. 447 or whatever. Yeah.
Whether
yes, please,
shareholder agreement was in shareholder agreement versus articles of association, which will prevail?
Yeah. See, articles of association is what is prepared and accepted at the time of incorporation of the company. So at the time of incorporation of the company, we decide that inter se the shareholders, the articles of association will prevail. But later on, what happens is, let us say there is an investor. We enter into a shareholders agreement. The existing shareholders enter into a shareholders agreement with the investors. So it is an understanding that they will invest money and they would be allotted so many shares and they would have these special rights. Whatever, you give them special rights, you give them the right to be the, you give them the right to appoint 3 directors, you will have 2 directors, and you permit the investor to have their person as managing director. So you give them various concessions in the shareholders agreement. Ideally, the shareholders agreement should be incorporated into the articles of association. So when it is incorporated into the articles of association or shareholders agreement becomes a part and the shareholders agreement prevails. In the sense, it becomes a part. So then the whole thing merges. The question of whether shareholders agreement prevails or articles prevails would not arise. So ideally, it has to merge. The shareholders agreement should become a part of the articles of association. It has to be amended and incorporated. So I hope I made it clear. So it's a very important question because you may probably get a question on these lines. Probably because you have disputes arising out of shareholders agreements. So the first thing that we look at when there is a shareholders agreement is whether the shareholders agreement have been incorporated into the articles of association. Yes, I think I've answered that. Any further doubt on that? I think if anyone is comfortable, you could also switch on your mic and raise questions that would make me feel more comfortable.
Correct. So there's one more question which says under section 241 subsection 2 of Companies Act, whether creditor or debenture holder who can file for operation and mismanagement.
So here what happens is section 241 subsection 2, strictly speaking, it's only meant for a shareholder. Now, whether a creditor or a debenture holder can per se raise it becomes, that becomes a situation. Probably I'll just read subsection 2 for clarification here. The central government, if it is of the opinion that the affairs of the company are being conducted in a manner prejudicial to public interest, it may itself apply to the tribunal for an order under this chapter. So if the situation warrants, the central government can refer. So a debenture holder or a creditor can make an application to the central government telling that there is large scale violation or breach of various provisions of law, and the shareholders are all hand in glove, and as such, this is not coming out. So please investigate into it. Then the central government may initiate action under subsection 2. So that is possible, provided that the applications under this subsection in respect of such company or class of companies as may be prescribed shall be made before the principal bench of the tribunal, which shall be dealt with. So it's a Delhi bench. So central government may refer it to the Delhi bench. So probably the position is the debenture holders or creditors may approach the central government, but directly approaching under section 241 or 241 for operation and mismanagement may not be possible, or is not possible. Not possible.
Okay. If anyone has any question, you can definitely ask in the audio. Before that, there's a question. Section 242, subsection 2, clause D, and section 222 of Companies Act, should it be read together?
1 minute. 242, 2D reads, I read the provision. Without prejudice to the generality of the powers under subsection 1, an order under that subsection may provide for. So 242 basically provides for the reliefs, and 2 without subsection 2 reads, without prejudice to the generality of the powers under subsection 1, an order under that subsection may provide for D, restrictions on transfer or allotment of shares of the company. Section 222. Imposition of restrictions upon securities, where it appears to the tribunal in connection with any investigation under section 216 or on a complaint made by any person in his behalf that there is good reason to find out the relevant facts about any securities issued or to be issued by a company, and the tribunal is of the opinion that such facts cannot be found out unless certain restrictions, as it may deem fit, are imposed. The tribunal may order the restriction on the securities. So the question is whether, see, section 222 would fall under a different chapter. It would strictly not come under operation mismanagement. So the situation under which you invoke 222 is different. When there is an investigation, you invoke 222. So if you look at the chapter headings, it would be different. So if you look at the index, you'll understand that 241, 242 will fall under the chapter of operation mismanagement. And as such, my remedy in a case of operation mismanagement would be under 242, 2D. 222 would be a situation which would arise in the case of an investigation by either the investigating authority or the any independent investigation ordered by the tribunal or any other person. So if you look at chapter 14 deals with inspection, inquiry, and investigation. So that the provisions are from section 206 to 229. So 222 would fall under chapter 14. But if you look at chapter 16, chapter 16 deals with prevention of operation and mismanagement, which starts with section 241 and ends with section 246. So the remedies are totally under different chapters. So under respective circumstances, the respective provisions would have to be invoked. Yes, I hope I've answered.
Yes,
so what I'll do is
there's one more question is, when there's a strike-off of a company, can we challenge the strike-off by filing a writ petition at Article 226 of the Constitution?
Surely. So it can be challenged on the ground that the legislation is very unfair, very harsh. The provision does not give scope for the person to justify his position. So he can challenge. But ideally, when there is a situation where it is possible to revive under 252, 252 is preferable, because as I said before, a writ petition cannot be entertained and will not be entertained. It's not that law prohibits or there is any specific legislation. Writ petition is not entertained when there is an alternative remedy available. So here you have an alternative remedy before the NCLT. So it wouldn't interfere. But nevertheless, you can file. But you can file it surely if you're going to challenge the wires of section 248. If you're going to challenge section 248 telling that is unconstitutional, it would only be a writ petition. And under that, you can seek for the relief that you're asking for. So possible. But practically speaking, that is not done, because 248 is held to be constitutional.
Okay. So if anyone else has any questions, you can also ask it through audio. That will be easier. So if you have, you can ask the questions over there in the audio. Hope
Sure.
everybody is
So,
understanding. Otherwise, we won't know whether you people are understanding or not. Yeah, I think someone, Padma has.
Hi, sir. Good evening.
good evening, madam. Good evening.
I have a doubt, sir. What are the circumstances where creditors have right to file a suit? In my opinion, creditors has right to file class action suit, and
Yes.
in case of insolvency also they have the right to file a suit. Is this right, sir?
Correct. Correct. You're absolutely right. You can file under section 245. Class actions can be filed under section 245, where the remedy can be sought by the depositors. So you have a member where you don't qualify. Now, let us say you have operation mismanagement. You need to have a minimum 10% shareholding. Even if you do not have 10% shareholding, you can come under section 245. Or depositors, you have deposit rules. If you are aggrieved and deposits are not refunded, you can approach. Now, when you are a creditor, you can probably, if the deposit rules are not complied with, so you have remedies even under the deposit rules. So you can approach the NCLT directly, and you can also approach the central government for taking action against the company. Insofar as the IBC provisions, a creditor can approach the NCLT depending upon whether he is an operational creditor or a financial creditor. If he is a financial creditor, he can approach. Now he has lent money, he becomes a financial creditor, he can approach under section 7. But the only problem is you have a threshold limit of 1 crore under IBC.
Okay, sir. Thank you, sir.
Welcome. Now, we look at another important aspect of litigation. I must say it's the alternative redressal forum or alternative redressal dispute forum, which is arbitration. You have questions cropping up, and not only that, arbitration actually is very important. You should know the interplay of arbitration and the other forms of litigations. Now, when you look at Arbitration and Conciliation Act 1996, let us basically understand what an arbitration is. If you have a dispute, you go to the court and the judge hears the matter, adjudicates, and gives his judgment. Now, this happens along with all other various matters. So your case is not exclusively being tried by the judge. But if your case is being exclusively tried by a person who is appointed as an arbitrator, who adjudicates the disputes, it is called arbitration. So arbitration is an adjudication of dispute. It's not the resolution of dispute. It's not settlement of dispute, because at times I really see definitions being given like it's a settlement of disputes, it's a resolution of dispute. It's not a resolution, strictly speaking. It's not settlement. It is an adjudication of dispute. It's decided who is entitled to the remedy. Just like what would happen in a court, you have an arbitrator doing the job exclusively for your case. And you have the Arbitration and Conciliation Act that governs the proceedings. It lays down the general principles. It lays down which law becomes applicable, which law does not become applicable. So, and then you have the arbitration as the most preferred alternative form of dispute resolution. Though we call it resolution, it's not a resolution, but it's an alternative dispute redressal mechanism. So here is a situation where you can have arbitrator, a sole arbitrator, or multiple arbitrators, but you should only have odd number of arbitrators. You can have 1, 3, 5. You cannot have 2 arbitrators. You cannot have 4 arbitrators. So let us say you have a sole arbitrator. He decides. He hears both parties. You have probably pleadings. He hears both parties. And I said it could be an adjudication, just like how it happens in a court. So you could have evidence, and then you could cross-examine, and then you have arguments, and then you have, instead of judgment, you call it award. Award, it is better. It is a reasoned award, in the sense, if generally it should be a reasoned award, unless the parties expressly agree that they are fined with an unreasoned, an award which is not reasoned. So an award which is reasoned is a speaking order. So it has to be, it has to contain reasons justifying the award. And an award between the parties is binding on the parties, and it is final. An award is final and binding on the parties. So when I say award is binding, it is binding. When I say final, is it that it does not have an appeal? The answer is it does not have an appeal. There is no appeal provision. Probably you take it to the civil court or to the high court to under section 34. And section 34 relates to setting aside of the award. It is not an appeal. What happens in an appeal is the entire pleadings is looked into, evidence is looked into, oral and documentary evidences are examined threadbare. So a job that is done by the civil court, trial court, is done again by the appellate court. But that is not what is done here. In section 34, only there are certain grounds on which the entire award is set aside. If the award is not in accordance with principles, if the award is not in accordance with the principles laid down under section 34, let us say it is in breach of public policy, principles of natural justice not followed. So you have the set of rules laid down under section 34, where only on those grounds the civil court can set aside. I just saw a question on the chat box which asks whether only civil cases can be referred to arbitration. Yes, only civil cases can be referred to arbitration. But even there, you have certain matters which cannot be referred to arbitration. Now, let us say matters relating to probate and succession certificate, testamentary or intestate succession or inheritance cannot be referred to arbitration. Family disputes between husband and wife, matrimonial disputes cannot be referred to arbitration. Certain other disputes, probably arising out of criminal matters cannot be referred to arbitration. Matters relating to maritime, or probably matters relating to martial law, or probably certain other disputes which are specifically prohibited cannot be taken up. Now, how does an arbitration happen? Arbitration happens if there is an agreement between the parties who specifically say that in case of a dispute, the parties shall approach an arbitrator for adjudication of disputes. In such situations, the matter can be referred to arbitration. And in a case when there is, let us say there is an MOU, a memorandum of understanding, you may call it a contract or an agreement or an MOU. If there is a clause that in case of a dispute, the matter shall be referred to arbitration, that clause is called an arbitration agreement. That clause stands apart. Even if the entire agreement were to be held invalid or void, the arbitration clause, the arbitration agreement stands separately, distinctly, and that is valid for all purposes. Now, for instance, there is an agreement to sell and buy goods which are prohibited. Based on that, one of the party makes a claim for money. Now, on the face of it, it is void. You cannot have a contract of that sort under the Contract Act. But is the agreement valid? The arbitration agreement valid? Yes. Based on that, can you take recourse to arbitration? Yes. What is the outcome depends on contract law and various other provisions of law. But what is important is an arbitration is possible. It stands apart. It stands distinctly. Now, I would like to draw your specific attention to a situation where there is no arbitration agreement. Now, this is, I have seen one of the case laws being referred to in one of the exams. Now, there is no arbitration agreement between the parties, but there is a dispute that crops up. And subsequently, there are exchange of emails and correspondences wherein the parties agree that the matter has to be referred to arbitration, and that they would ideally want the matter to be adjudicated at the earliest by the arbitrator, and one of the party files a civil suit. As per Section 8 of the Arbitration Conciliation Act, when a civil suit is filed in a case where there is an arbitration agreement, the civil court has to specifically refer them back to arbitration. The civil court should not entertain the matter. So what happens here? The matter would be referred to arbitration. Why? Because Section 7 makes it clear that even if there are correspondences or emails or any subsequent arrangements where the parties mutually agree for arbitration, the arbitration the said arrangement would be considered as an arbitration agreement. So it is not necessary that you should have an arbitration agreement in a contract. It can be done it can be accepted and agreed to even in correspondences, by way of correspondences. So arbitration is pretty important. And now invariably you see in most of the cases, arbitration becomes a part of the agreement, part of the MOU. Because admittedly, it is pretty fast. And in an arbitration, you don't have principles of Evidence Act. You don't have principles of various other legislations, which probably could go by the strict interpretation of the Civil Procedure Code. So CPC is not applicable. Evidence Act is not applicable. Limitation Act is applicable. So what happens here is the parties may choose to only go by oral evidence and not parties may prefer to go only with documentary evidence and may refrain from reading oral evidence and quickly close the arbitration proceedings. Now, the question that could probably crop up and which have time and again cropped up is whether an arbitration can be entertained if the dispute can be split. In fact, this matter came up for consideration in Sukalya Holdings case before the Supreme Court, where the Supreme Court held you cannot split the case, the dispute, to be tried one half by the arbitrator and one half by the civil court. So it has to go to the arbitrator entirely for deciding the dispute. But there could be another situation where there are certain parties who are parties to the agreement, and there are a few parties who are not parties to the agreement, but they are parties to the dispute. Can you file an arbitration even in respect of those persons who are not parties to the agreement? The answer is no. However, if these are companies which are interconnected, group companies, and the intention becomes clear that they are back-to-back arrangements and that the agreement is so done to ensure that the entire transaction goes through, then even if a person or a company is not a party to the arbitration agreement, he can be brought into arbitration. So that is the position of law. Now, there are certain other questions that we probably will have to look at. Now, if there is an arbitration agreement, can we file an insolvency petition, insolvency application under Section 7 or Section 9? This aspect has been considered in various cases, and it has been held that even if an arbitration is pending before an arbitrator, the matter can be referred, an application can be filed or preferred under Section 7 or 9, and it does not bar filing of an application before the NCLT under IBC. So this is something that you'll have to keep in mind. Probably the arbitration could be for recovery of money, but any proceeding under Insolvency and Bankruptcy Code is not for recovery of money. Ultimately, the intention may be to recover money, but the main intention is to ensure that there is resolution of the company. So we have the corporate insolvency resolution process where the company is sought to be revived and it is tried to put the company back on feet so that it gets back to operations and runs its business. So if, let us say, there is a suit for recovery, or let us say there is an arbitration pending for recovery, can I file an application under Section 7 also? The answer is yes. The same plaintiff, the same claimant before the arbitrator who has filed for recovery of money can also file an application under Section 7 or Section 9, depending upon the situation, before the NCLT, because the intentions or the purposes are totally different.
Sir, small doubt, sir.
Yes,
sir.
Yes,
When there is a dispute to the creditor, if there is already a dispute exists for the creditor, that litigation is going on, then we can, whether it is possible to file under the insolvency law, sir? when there always already a dispute is there, without closing of the dispute of the creditor, if something the dispute is going on, without the dispute closing, whether we can raise that same issue in the insolvency proceedings, sir?
That's a very important question. It requires a little bit of elaboration. Now, your question, whether a civil suit in respect of the same dispute can be raised before the insolvency and before the NCLT without closing the dispute in the civil case. Now, that would depend on whether the person is a financial creditor or an operational creditor. Now, if I am a financial creditor and I have filed a suit for recovery, or I have filed an arbitration petition or arbitration for recovery, and I am a financial creditor, I am, irrespective of what dispute the defendant takes or the respondent takes, I am at liberty to still file a petition, an application under Section 7 before the NCLT. Now, if the person is an operational creditor, let me go back, because what is required under Section 7 is debt and default. If there is a debt and if there is a default, the petition has to be admitted before the NCLT for corporate insolvency resolution process. So now, for instance, let us say I'm pursuing my remedy before the civil court or before the arbitrator for recovery of the loan that I have given. I'm a financial creditor. I'm trying to recover the loan that I've given. I know for a fact that it is totally going down and the company cannot be revived, or it's in a very bad shape. Then I go before the NCLT and file a Section 7 petition. Only two things I'm required to prove as financial creditor. One is there is a debt and there is default. If I prove these two, it's done. Of course, limitation becomes important. Now let me look at the second situation.
Yes, right. Yes, sir. So a person can file a suit in either under IBC. The answer is yes, right, sir.
Sorry, I couldn't get your question. You said a person would file it.
File a petition, file a suit, and an arbitration proceedings is happening, and he has liberty to approach NCLT. I felt that answer is true.
You feel the answer is true?
Yes, sir. Yes,
no.
Sir.
No, you don't have to feel it true. It is absolutely true. It is correct. It is absolutely possible.
Of like financial creditor and operational creditor, creditor has right to approach NCLT and IBC at any point of time, as you said, the default and there exists default and debt. So correct. I felt it's true.
Okay, you felt it is true.
Yes, sir.
Okay, fine. Thank you for acknowledging that. So now the point is, let us look at the second situation of an operational creditor. For an operational creditor, he has to prove that there is a debt, that there is a default. Probably, he has not paid. Even default is not required. There is a debt. Debt is what is required to be proved. He has not repaid it. Now I can approach the NCLT, but if the defendant has disputed the debt in the arbitration, in the civil court, then the NCLT will not be in a position to entertain it, because the defendant will approach, will be summoned, and the defendant would respond by telling that even prior to initiation of the proceedings in the NCLT, I've already disputed it, but the dispute should be genuine. Now here is a situation. Now let me make it clear. When I say I have disputed it, this person should have made a counterclaim or a set-off. If he has not made a counterclaim or a set-off before the arbitration or before the civil court, then he cannot say there is a dispute. In which case, even in such a situation, the operational creditor can make a claim before the can make an application under Section 9. I would repeat it. In the case of an operational creditor as well, an application can be made under Section 9. But however, if the respondent or the corporate debtor takes a contention that there is dispute and he is in a position to prove that there is a dispute, then probably you will have to show that there is no pre-existing dispute and the dispute is probably sought to be created for the purpose of defending themselves. So this is where we look at Mobilox Innovations Private Limited versus Curuza Software Private Limited. where the question that arises is whether regarding the existence of dispute. Regarding the existence of dispute, if there is an existence of dispute prior to the filing of the Section 9 petition, then the NCLT may not entertain it, or the NCLT would not entertain it. If you look at the definition of dispute, I would read the definition of dispute. It is defined under Section 5 subsection 6. Dispute includes the suit or arbitration proceedings relating to A, existence of the amount of debt, B, the quantity of goods or service, or C, the breach of a representation or warranty. Now, for instance, I hope I made myself clear so far. For instance, now let us say I have supplied fans. I have supplied pedestal fans and ceiling fans to a retailer, and he has in turn supplied it for being installed somewhere, and he has still not paid. Then I raise my invoice, I issue a notice. It is mandatory to issue a notice under Section 8 of the IBC. I issue a notice. After the effects of 10 days, I file an application under Section 9 before the NCLT and seek for recovery of the money. Now, in which case, if the respondent appears before the tribunal and says, please look here, the fans that were supplied by him are defective. I have supplied it, I have sold it to my customer and they have installed it, and they have come back telling that they are defective. As such, I'm not liable to pay the amount. The goods are defective. So that amounts to a breach. In the sense, you look at 6C. Dispute includes a suit or arbitration proceeding relating to the breach of a warranty or representation. So let us say, there is a warranty in terms of the performance of the fan. So what happens is, there is a dispute, and that becomes a ground of defense to the corporate debtor. So I have made myself clear there. So it is important for us to know that the IBC has an overriding effect over all other provisions of law and over all other legislations. We are required to look at Section 238 of the IBC, which deals with a situation where it says that it has the non-obstante clause that prevails over all other provisions of various other legislations. 238, provision of this code to override other laws. The provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having the effect by virtue of any such law. Now, I would advise you to kindly keep in mind some of the sections in every act. Companies Act, as I said, 241, 245, class actions, 241, 242, 72. So these are 59, rectification of registers. Now, these are some of the commonly fought cases. Probably you can you can use Rule 11 of the National Company Law Tribunal rules, which deals with inherent powers of the NCLT. So these are some of the provisions that you should keep in mind. When we look at IBC, we have Section 7, application filed by a financial creditor. Section 9, application filed by an operational creditor. Section 238, which is an overriding provision in over all other laws. 238A, which was brought out by way of an amendment, which makes Limitation Act applicable to IBC proceedings. So these are some of the provisions that you must keep in mind. Section 31, resolution plan. Section 33, liquidation. So these are some of the provisions that you must keep in. Section 53, waterfall. That is the manner in which the liquidation proceeds should be distributed. Section 52, what in case a person or a bank institution stands outside the liquidation and says he would sell his assets, sell the security. So these are some of the provisions that you must know. So if you look at Section 238, now let us say Section 14 becomes important, moratorium. What is moratorium? The moment a petition or an application under Section 7 or 9 is admitted, the NCLT passes also, it flows admission involves moratorium being passed. So no cases or no precipitatory action or no recovery actions can be taken as against the company or the securities given by the company or the assets of the company. So section 14 is a moratorium order which the NCLT passes, and by virtue of section 238, this provision overrides all other legislations. So 238 read with section 14 makes it very important to note that no other court or no other forum can proceed with any action against the company, against the corporate debtor. So if you look at a situation where there is an arbitration pending, I was previously examining a situation where an arbitration proceeding is pending for recovery, or probably a civil suit is pending for recovery. Now the same plaintiff or the claimant files an application under section 7 or section 9 before the NCLT. What happens is, on admission of the application, the proceedings before the arbitrator or the proceedings before the civil court get stayed. There is a stay of proceedings. Now let us say there is an execution proceedings for recovery of money, that also gets stayed. Let us say a bank which has lent money to this corporate debtor has issued a notice under section 13 subsection 4. Yes, I think I'm addressing the question that is posed now. Let us say there is a notice issued under section 13(4) and possession of the property is taken. The bank cannot proceed further. It cannot auction the property. It cannot bring it to sale. It cannot take physical possession of the property by enforcing section 14. So it stops wherever proceedings have been taken. So it stops at the place where actions have been taken. So none of the institutions, banks, or persons can proceed against the company once an order of moratorium is passed. When a matter is admitted by the NCLT, an insolvency, an interim resolution professional is appointed, moratorium order is passed, and a paper advertisement is ordered. So these three things are done when an application, either under section 7, 9, 10, is admitted by the NCLT. So moratorium is the one important provision in the whole of IBC. So you must be aware that proceedings cannot continue anywhere as against the company when there is a moratorium. Moratorium continues to be in force from the time the application is admitted till the time the company is pushed into liquidation under section 33, or there is a resolution plan that is approved. So either a resolution has to be approved or there is an order of liquidation. Till then, there is a moratorium. What happens after moratorium? You can either proceed with the, if there is a liquidation order, you cannot file a fresh case under section 33. You cannot file a fresh case, but you can proceed with existing cases. And ideally, when you look at liquidation proceedings, the procedure, all creditors or claimants are required to make their claims before the liquidator and agitate the matter before the liquidator or the NCLT. So ideally, the situation is where the NCLT brings every dispute under its umbrella to ensure that at one place, the entire assets and liabilities are marshaled and the creditors are settled, the debtors are made to pay the amount to the company. So the amounts are received from the debtors of the corporate debtor and paid to the creditors. But however, this has its own procedure. So the procedures are accordingly to be followed and the whole process goes on. So that is where so now given the situation, now we have Sarfaesi Act. There is a securitization of assets, and reconstruction of financial assets and enforcement of Security Interest Act 2002. Now, when this was enacted, this was a legislation which overrode everything, which was prevailing provision as against all other legislations. Now, IBC overrides this one. So under Sarfaesi, you have the power that is given to a bank or a financial institution to issue a notice under section 13(2). And 13(2) is a notice given for the purpose of ensuring that the creditor is given, the debtor or the company is given 60 days time to repay the money. In spite of the section 13(2) notice, if the amount is not repaid within 60 days, then a 13(4) notice can be issued by the section 13 subsection 4. Notice section 13 subsection 4 of the Sarfaesi Act. Notice can be issued by the bank or financial institution taking over the assets. When I mean assets, it's the security given. When the assets are given as security, only those assets can be taken over by the bank or financial institution. Now, let us say, let me give you an, what is required here is an understanding of the legislations. What is the purpose of each legislation? You have the erstwhile legislation, which was the Recovery of Debts Due to Banks and Financial Institutions Act 1992. Now it is presently amended and it is renamed as Recovery of Debts and Bankruptcy Act. Now, this legislation has its own jurisdiction to play under. Sarfaesi has its own jurisdiction. IBC has its own jurisdiction. So what is the purpose of each legislation? I will very quickly say, I would very quickly draw you to the relevant aspects. Now, under Sarfaesi, what happens is the bank can enforce the security and attach the properties which are given as collateral or security. Security could be by way of mortgage or charge, movable, immovable, whatever. It can enforce the security interest that is in its hand and recover the money by auctioning or selling it. Now, it may so happen that the liability is, let us say, 100 crores. The security interest, when auctioned, comes to around 80 crores. There is still a shortfall of 20 crores. What do I do for recovering this? There are no other assets which have been given as security. So what I do is, then I can approach under the Recovery of Debts and Bankruptcy Act. I say that the company has so many assets, A, B, C, D. Please ensure that those are sold and the Debts Recovery Tribunal give me the money that is to which I am entitled to. So what happens is the DRT, Debt Recovery Tribunal, hears the applicant. The bank is the applicant. We call the original application, OA. The original applicant, the bank is heard. The respondent, who is the borrower, is given an opportunity to file his written statement, and then both are heard. And if required evidence, the point is, unless you prove that there is a necessity for evidence, there is a fraud, something has gone wrong, evidence is not led in a Recovery of Debts and Bankruptcy Act. And then it is argued, and then the DRT, on being satisfied, would issue a recovery certificate. Based on the recovery certificate, the recovery officer attached to the Debts Recovery Tribunal would attach and sell the other properties of the corporate debtor and recover the money. Now, what happens is, under IBC, the intention is not recovery. Let us appreciate Sarfaesi was for the purpose of selling and recovering the assets that were secured, charged, mortgaged. The purpose of RDB Act was to sell assets, even those which were not charged or mortgaged in favor of the bank. The intention and the purpose and object of IBC is to ensure that the company is revived. The assets of all the stakeholders is maximized. Now, there could be a possibility that there is a resolution plan during the CIRP process, the corporate insolvency resolution process. There could be a situation where there is a resolution applicant who says that I will take over the entire business as a going concern and pay the money. In which case, the company goes out as a running concern. In such a situation, the IBC becomes very effective. It's a maximization of value. That cannot be achieved under either Sarfaesi or RDB Act. It can only be achieved under IBC. So the intention of IBC is to ensure that the company is running. What happens is, unfortunately, when it is under Sarfaesi or RDB Act, the company's business is closed, operations shut down. But IBC, the operation is kept running as far as possible. as far as practical and feasible. And then the company is sought to be taken as a going concern if possible. If not possible, at least bits and pieces of whatever can be made as a going concern is split and taken out. So the value is maximized for the benefit of all the stakeholders, and it is also in the interest of the nation and economy of the country. So this is what broadly the IBC looks at. Now, if there is a question that is posed in the examination that the petitioner or the application is filed under Section 7 for the purpose of recovery, and he justifies that there is a debt, there is a liability, and that the petition is filed for the purpose of recovery, in all probability, the petition has to be dismissed, because the intention is not recovery here. The intention is a CIRP. Now, if the person who has filed an arbitration proceeding or a civil suit, let me be clear here. Whenever I refer to an arbitration proceeding or a civil suit, I mean either. You cannot have both an arbitration proceeding and a civil proceeding. It's either. Now, when an arbitration proceeding is pending for recovery, or a civil case is pending for recovery, if the same plaintiff or the claimant goes to the NCLT under Section 7 of IBC and says, I have filed this application for recovery of money, please pass an order for the purpose of quick recovery, you can be assured the NCLT is not going to admit the petition, because the intention is different and the relief sought for cannot be granted by the NCLT. The petition has to be dismissed. So the prayer has to be for a corporate insolvency resolution process, and that's it. You cannot do, once you file as an applicant, and if it is admitted, and there ends your role, you have no more control over the proceedings before the NCLT under the IBC. So I hope I've made myself clear. So these are concepts that become very important for you to understand and appreciate, because at the conceptual level you will be tested. Now, when I say when we say it's an open book exam, it is not that they are testing your ability to reproduce what is there in the book. They are asking you to read between the lines, understand, analyze, and then answer the question. So that is where you are required to go through the questions, the case laws, to answer the questions that would appear in the exam. Now, probably you can use the books to clarify some position. Now, probably you are in doubt. What is the extent of duration of the moratorium? Or what is the sanctity of Section 12 of the IBC? Let me put a question here. Section 12 of the IBC says that there shall be, the CIRP, the Corporate Insolvency Resolution Process. I'll come to the sufficient cause. Corporate Insolvency Resolution Process shall be completed in a span of 180 days, that is 6 months. Now, what happens in case it goes beyond that? So that is where there was an amendment made, and it said 330 days is the outer limit. An outer limit of 330 days was laid down by way of an amendment. Now the question that cropped up was, in fact, I must say, the provision says, irrespective of whether there is a litigation pending, there is a stay, whatever, if 330 days has expired, you must push the company into liquidation. Now, this provision was challenged, this amendment was challenged before the Supreme Court, and the Supreme Court clarified that this span of 330 days is only directory and not mandatory. You cannot stick to this date if the situation warrants an admission and a stay by the High Court. You cannot stick to it when the situation warrants extension of time. You cannot stick to it if genuinely the circumstances are such that the period of 6 months is not sufficient. Now you had COVID pandemic. Extensions are required to be granted, and the power has been granted by the and it has been clarified by the Supreme Court that the NCLT has the power under the facts and circumstances of the case to grant extension of time. So such being the case, Section 12 is only directly. So that is where what happens is, if you only read Section 12 without knowing that the case, SR Steel, without knowing that the span of 330 days is only directory, you will be under the wrong impression that 330 days is sacrosanct and under no circumstances you can extend it. And if you exceed 330 days, it gets into liquidation. So you must, that is the reason why we have case laws which clarify and even amend or even change the law. So here, there was a modification of the provision by the Supreme Court. So it becomes important for you to know the legislations. Now, we also look at certain other provisions of the IBC. Let us look at section 238. I think that was a question that was being posed. Section 238A, 238 is a overriding provision. 238A deals with limitation. Now, there was a lot of problem that actually started cropping up. Old time-barred debts started cropping up before the claimant started filing and agitating time-barred debts. Now, what happened there was a situation where, and if these applications are entertained, you're going to open all old time-barred debts, and that is going to create a lot of problems. And that is not the intention of the legislation. As such, the IBC was amended to make it clear that Limitation Act is applicable. Because in one of the cases, the NCLT had interpreted section 238 and had laid down that Limitation Act is not applicable to IBC proceedings. And that made it necessary for the Supreme Court to clarify that the Limitation Act becomes applicable, even though there is no specific mention of it. Now, if you look at section 238A, Limitation Act becomes applicable. Now, when we say Limitation Act becomes applicable, do all the provisions of the Limitation Act become applicable? So that is where you have various case laws which deal with various provisions of the Limitation Act being analyzed, and the purpose of the provision vis-a-vis the IBC is interpreted, analyzed, and then the Supreme Court has come out with clarification in many cases where it has laid down that section 5, when I say section 5, now let us say there is a delay in filing an application under section 7 or section 9 for some justifiable reason. Section 5 of the Limitation Act says if there is a sufficient cause, you can entertain the application or the appeal, but it does not give the condonation of delay in the case of a suit. So let me explain it to you. If there is a suit for recovery, generally the time span is 3 years. If you do not file a suit within 3 years, you lose out on limitation. And even if there is a delay of 1 day, 3 years and 1 day, the court cannot entertain it. There is no question of condonation of delay in the case of an original suit before a civil court. So where is it that the section 5 operates? Section 5 of the Limitation Act operates only insofar as applications and appeals. Now you have to file an appeal from a judgment within 90 days. You don't prefer an appeal within 90 days. Then you can invoke section 5 and say, please see that these were the reasons. There was this problem because of which I couldn't file in time. So please condone the delay. Please condone. You don't file the application within the time. It is condoned. Now let us say for some reason the defendant dies. You have to file an application within 90 days. You don't file the application. I can file an application for condonation of delay to set aside the abatement. Automatically it abates. The proceeding abates as against the legal representatives if the suit is not filed within 90 days. So an application can be filed for condonation of delay under section 5 to set aside the abatement. So that is allowed if you give sufficient reason. So that is where you have the sufficient cause. Now the question that cropped up is section 5 applicable to section 7 applications? On the face of it, when you see, the word used is application. Section 7 application. So it is an application. What is the time specified under the Limitation Act? There is no specific time specified. So when you have a look at the Limitation Act, the last clause relating to applications is Article 137. So you have a schedule at the end of the Limitation Act. The schedule, you have section in the Limitation Act. In the schedule, you refer to each of the items as articles. So Article 137 deals with miscellaneous or residuary clauses. Now, if there is no specific time period mentioned, then the residuary clause would kick in, and it mentions that the time span is 3 years. So you will have to file an application within 3 years. So it was held that what is applicable in the case of Section 7, Section 9 applications is Article 137, and that is 3 years. Now the next question that cropped up was, is Article 61 applicable? Article 61 deals with mortgage, invocation of mortgage, which gives a time span of 12 years. The limitation is 12 years. Is 12 years available? The answer is no, because that is redemption of mortgage, which is a suit. You can invoke the mortgage and recover the money by foreclosing the mortgage under a civil suit, which is to be preferred in a civil court. So that deals with a suit and not an application, and as such, you do not get the benefit of 12 years. So here it is 3 years only. Now, so the point is, since it's an application, it was held that Section 5 is available and an application can be filed under Section 5 seeking for continuation of delay. Now, here in Section 5, in fact, the Supreme Court went to the extent of even holding that Section 5 application need not be filed, because if you look at Section 5 closely, what is required is the reason for the delay. In fact, I must refer to this case law, Seshnath Singh and another versus Baidyabhati, Shirofuli Cooperative Bank Limited. In fact, I have made a PPT, PowerPoint presentation in which we have captured this. This makes it clear that Section 5 is applicable to IBC proceedings, and that that an application need not be specifically made. Now, if the application contains the reasons for the delay, and they by per se substantiate the reason for the delay, that would be sufficient. The Supreme Court said such a reason has to be considered for condonation of delay. Because Section 5 does not contemplate the filing of a separate application, even Section 5 application need not be filed. Now, is Section 14 applicable? Section 14 is a situation where I go before a wrong forum and then approach the correct forum. The time spent before the wrong forum, can it be deducted from the time limit of 3 years? The answer is yes. So even Section 14 is available. Is Section 18 available? Section 18 of the Limitation Act. Section 18 of the Limitation Act deals with extension of the time period. Now, let us say Article 137 of the schedule says that you will have to file an application within 3 years. If the application is not filed within 3 years, you lose out on limitation. So what happens is Section 8 says, however, the limitation can be extended by an acknowledgement of debt by the corporate debtor. I say corporate debtor, but Section 18 says any debtor, if he acknowledges the debt, the limitation gets extended by another 3 years. So here, if the corporate debtor acknowledges the debt in writing, the period of limitation gets extended by another 3 years. Now, the question that cropped up was, is an acknowledgement, is the mentioning of the liability in the balance sheet an acknowledgement of debt, and would that be an extension under Section 18? In fact, in Padma Kumar's case, NCLT held that you cannot consider the balance sheet statements, because that is done in compliance of law, and that is not an acknowledgement of debt, and that is not addressed to the creditor, because Section 18 says it should be addressed to the creditor. This is not addressed to the creditor. As such, it is not an acknowledgement of debt. But however, that was considered by the Honorable Supreme Court in Asset Reconstruction India Limited versus Bishal Jaiswal and another, 2021 SCC Online SC 321. Now, when I read this, ARCIL, that is Asset Reconstruction Company of India Limited, Asset Reconstruction Company India Limited versus Bishal Jaiswal, 2021 SCC Online SC 321. This is called the citation. This is the case law that we are referring to substantiate our case. We use precedents to support our stand. Now, in this case, the Supreme Court very clearly laid down that the statement in a balance sheet acknowledging the debt is sufficient compliance of Section 18, and it amounts to an extension of the liability. And though it is not addressed to the creditor specifically, it's an admission done openly. And as such, the aspect has to be, the settled position is that an admission in a balance sheet amounts to an acknowledgement of debt under Section 18. So what happens here is the trigger point is the default. So in the case of a financial creditor, you're required to prove that there is a default, that there is a debt, there is a default. If there is a debt, there should be an extension of the liability. Either it is within the original period of 3 years or extended period of 3 years. And during that period, when the liability is alive, a notice is required to be issued, or probably the default becomes clear. Now, for instance, now let us say, in the case of banks and financial institutions, they generally follow this prudential norms, where if they find that a company is defaulted or a debtor is defaulted, they declare it as a non-performing asset. So for all purposes, declaration of the date of declaration of the asset as a non-performing asset is taken as the date of default. And in any other case, a default, if there is an agreement, the agreement is looked into for the purpose of deciding the default. But however, I must say the best means would be to confirm the default through a notice. A notice would be better, would be the best option available to indicate that there is a default. So you issue a notice telling either a bank, financial institution, or an individual or a corporate. It is better to issue a notice to the corporate debtor telling, please note that you have borrowed so much, you are liable by way of interest to this extent, you've defaulted, you've not repaid for the last so many months. Please note that if you do not pay within so and so period, if it's a based on the agreement, if it's a loan recall, which you can recall at any time on demand, you can do it, or you have to give the period that is contemplated under the contract, issue the notice, and after the expiry of the period, you can say there is a default. So debt and default have to be proved. Please understand, just because there is limitation, you do not get the cause of action to file an application under Section 7. The trigger point is a default. So debt and default. So with this, I will very quickly take you through some of the case laws that have been discussed in the study material. Of course, if there are any doubts, I think I'll clarify that before we proceed further. Or if you would want me to cover anything else, I would quickly look at it.
Sir, one more thing from my side. If you feel there is a need for a break, we can even take a break and come back based on what you suggest.
I think I'll just take, I think we'll wind it up by 7 o'clock, isn't it?
Yes, sir, whatever you suggest.
Okay, then I'll just have some water, but I think you can just say what the questions are.
Sure.
I'll answer them.
Okay. So here we would really encourage if people can ask the question in audio. That is much more engaging. That is the only reason why we are requesting if people can ask the question in the audio. That would be better. So we have a question here, Sumadhi, whether Limitation Act applicable to arbitration and whether arbitral award can be made appeal.
Yeah, so that is also important because this is also tested. Arbitration Conciliation Act is very much there in the syllabus, and it's the thing in thing today. So as I said, we don't have an appeal from an arbitration, but we have Section 34 proceeding, which deals with setting aside of awards. If it is satisfied, if the court is satisfied that the award is against public policy, it is not considered the evidence, it has totally bypassed the procedure, the award is not reasoned, there is no reason for the award, or probably principles of natural justice have been breached. So these are the set circumstances under which the entire award is set aside. the civil court or the high court cannot get into the merits of the case. It cannot examine the evidence. In an appeal, as I said, they can examine the evidence, the oral and the documentary evidence. Neither the oral nor the documentary evidence is examined in section 34 setting aside proceeding. So I wouldn't say it's absolutely not an appeal. So there is no appeal from an award. That is why I, in fact, in the beginning made it clear. Generally, when you have an arbitration clause, it reads, the party shall refer the dispute, if in case there is a dispute, the party shall refer the dispute to an arbitration or to a sole arbitrator. The award shall be binding on the parties. So when I say the award shall be binding on the parties, it means that there is no appeal. You only have a section 34 proceeding. Generally, an arbitration clause would also further contain the arbitration shall be in English. The venue of arbitration shall be so and so, shall be Bangalore, whatever. So these are the things that you could bring it out in an arbitration clause. So you could also say, prior to arbitration, the party shall explore all possible means to amicably settle the dispute. So this is the way it generally goes. Now, if you look at a proceeding further from 34, now let us say the award is not set aside, it is confirmed by the civil court. Section 34 is dismissed. Section 34 suit, we call it the arbitration suit. Let us say this arbitration suit is dismissed. From there, you have a remedy under section 37. That is an appeal. That's an appeal on the order of section 34. So it's not an appeal of the proceedings in the arbitration. So again, there is no appeal in the strict sense of the arbitration proceeding. So there is strictly speaking no appeal from the arbitration. There is no appeal on the award. From the arbitration, arbitration suit under section 34, there is an appeal under section 37, where the proceedings under section 34 are examined by the High Court. So apart from that, if you want to further go to the Supreme Court, it's a special leave petition under Article 136 of the Constitution of India. So I think I've answered that question.
Yes.
Is there any?
Yes, sir. Yes, sir. There's one more. Already, Sarfaesi is pending against the company and whether IBC proceeding can be initiated. And
Yes.
in case if IBC initiated, then under section 14 moratorium starts, which can stop the enforcement under section 13 of Sarfaesi. Is it correct?
Yes, absolutely, it's correct. It's absolutely correct. So when you have a Sarfaesi proceedings and a notice has been issued under section 13(4) by the bank or financial institution, taking over the constructive possession of all the assets that have been given as security to the bank or financial institution, even at that point in time or at a point in time just prior to that, you can approach the IBC, and if it is admitted, actions of the bank are stayed, in the sense they cannot further precipitate by taking steps for sale. Now let us say I have taken steps for taking possession under section 13(4). Under 13(4), it's a constructive possession. The bank issues paper advertisements, paper notices, issues, probably it also affixes the notice on the property to say that we have taken possession of the premises. That prevents the owner or the corporate debtor from selling those properties. Now what happens is, subsequent to that, the bank has the power to auction the property. But if there is a moratorium, then the bank cannot go further under Sarfaesi Act and auction the property. In fact, I must say, I specifically mentioned that constructive possession is taken. Once the moratorium is passed, even physical possession cannot be taken. Now, what happens is, for taking physical possession, the bank approaches the magistrate and seeks, with the order of the with the notice that is issued under 13(4), the order of the magistrate is obtained for taking physical possession with the support of the police. So even that cannot be done. So no further action can be taken. So no further action can be taken. So this is a very important point. So Sarfaesi proceedings also have to be stalled when there is an IBC matter which is admitted by the NCLT.
Whether trade union can act as operational creditor and file case against corporate debtor under section 9 of IBC.
Yeah, trade union. In fact, there is a case law. In fact, I have also referred to it in our presentation. One of the slides which says that, which clearly, in fact, this has been discussed in detail, and the trade union has been held to be a operational creditor and is entitled to make its claim. So, in fact, that case is discussed. In fact, I must say that is also there in the study material. So it is considered to be a operational creditor. And why is it so? Because now the workman, if you look at section 53, waterfall mechanism, the workmen are treated on par with the secured creditor. And the position, there is the provision of the IBC makes it clear that a security with a secured creditor has to be charged, has to be shared pari passu with a workman. Now, for instance, I'll give you an example here. Now, let us say I am a secured creditor, and if there is a asset security in my favor, I am a institution, financial institution. Let us say the security is worth around 1 crore. I sell it. I get 80 lakhs out of it. Now, what happens is 50% of that I have to set apart and give it to the liquidator. Now, to the extent of 50%, the workmen have a charge. Though I have the entire security with me, the corporate debtor mortgages the entire property in my favor as a security. By virtue of the provisions of the IBC, I am required to give 50% of the sale proceeds to the liquidator. So the workmen have a charge on the security which the financial institutions also have. So the position is the trade union has a right on the security. And apart from this, there are various other social legislations which make it very clear that PF, ESI, and they have to be settled terminal benefits. So their payments have to be made. So to ensure that that is complied with, the trade unions are given the representative capacity and they come in as operational creditors. So they take this as an operational creditor. Their employees, workmen, they take it as operational creditor. And trade union registration comes under the definition of registered trade unions come under the definition of person under section 3 subsection 23G. It reads any other entity established by a statute. So it's under the Trade Unions Act. So it's an entity established by a statute, and as such it gets the position as a person. So by virtue of being a person, a trade union gets into this statutory position and is considered as an operational creditor. So that's a good question. It's an important question also.
Yes, sir. Sir, going further, whether the concept of sufficient cause is applicable under IBC?
Yes, exactly. So that is where, in fact, I referred to this case law. You could also make a note of this case law. Sheshnath Singh versus Vaidyabhati Shirofuli Cooperative Bank, 2021, SEC Online, SC 244. Of course, I'll be sharing the slides now. This case law makes it very clear that Section 5 is applicable. Section 5 of the Limitation Act is applicable to IBC proceedings. So in case there is a delay, I have exceeded the period of 3 years. If I can give a sufficient cause for not filing it within a period of 3 years, the delay can be condoned and the NCLT has the power to condone the delay. Now, another point which I must say is if you look at section 238A, the Supreme Court is making it very clear that limitation, section 238A is clarificatory in nature. It is not that it is inserted and it takes effect from that particular day prospectively. It says section 238A, which deals with, which makes it clear that Limitation Act is applicable to IBC proceedings. It is only clarificatory in nature and that it shall apply retrospectively. It shall apply retrospectively. So if there is a debt which became time barred in 2015. You cannot say the code came in 2016, so the time starts running from 2016, or the amendment came in 2019, as such it starts running from 2020. No. So it acts retrospectively, and section 238A is only clarificatory in nature. This is also important for you to take note of. So please keep that in mind. Yes, Alok.
Yes, sir. Sir, you want to answer one more question, or you want to share the screen?
Yeah, please. I'm comfortable. Please.
What,
I think that.
What is the difference between Section 10 initiation under IBC and the voluntary winding up by a company?
Very good. Now, this is a very important question. Section 10 is a IBC proceeding initiated by a company, corporate applicant, where it knows it is not in good shape. There is no funds available, not available. It's unable to meet its liability. And at the same time, I must say there is another proceeding under Section 59, where the voluntary application, where the company is doing well but wants to ensure that it is dissolved and liquidated and then dissolved. Now, probably if you also look at voluntary winding up by a company under the Companies Act, it cannot be initiated by any of the creditors. Let us be very clear. 272, if I'm right, Section 272 of the Companies Act cannot be initiated by a creditor. It can be done by the ROC, by the central government. So that totally goes out of our bounds. So an individual cannot initiate proceedings for winding up like the way we were doing it under the Companies Act 1956. So if you look at Section 59, voluntary liquidation of corporate persons, voluntary liquidation of corporate persons is a situation where the company is doing good, but it wants to liquidate for various reasons. So if you look at Section 272, petition for winding up, subject to the provisions of the section, a petition to the tribunal for winding up of a company shall be presented by the company, any contributory or contributories, all or any of the persons specified in clauses A and B, that is contributory or the company, the registrar, any person authorized by the central government in that behalf, or F, in the case falling under clause B of Section 271 by the central government or the state government. So it totally goes out of the hands of a creditor. So it's not a situation where we can initiate as a creditor. I hope I've clarified all the three situations: Section 10, Section 272, and Section 59 of the IBC.
Okay. So there's one more. Section 52 of IBC states that secured creditor can have the option to realize securities outside liquidation proceedings or choose to relinquish its securities, but under Section 33 subsection 5, bar to file case and legal proceedings like moratorium. Then how can the secured creditor enforce his security interest? Yeah, in fact, I wanted to address that. It's a very good question. Very good question. So now let's, I need to give a little bit of explanation even before I start, answering the question. Now, let us say the company has gone into liquidation, a situation where the company could not be revived, no resolution plans came, or the resolution plans that came could not be accepted. So it gets into liquidation under Section 33. Now, when the company is in liquidation, you have the liquidator appointed. The RBI, the NCLT appoints a resolution professional as a liquidator, or the RP can himself be appointed as a liquidator, can continue as a liquidator. Now the point is, when there is a liquidation, all the assets have to be brought into the hands of the liquidator. Assets of the corporator have to be brought into the liquidator's hands, and all the claims of the creditors have to be shortlisted and indicated as to what amounts are actually payable. Now this work has to be done by the liquidator, and then he sells all the assets, auctions it, sells it, or ensures that arrangements are made. And as indicated, all suits come to a standstill. So what happens is, it is actually, this is done. Though there is no moratorium in liquidation, the proceedings, if you look at Section 33 subsection 5, proceedings can continue, but no fresh proceedings can be initiated. And even if any fresh proceeding has to be initiated, permission of the NCLT has to be obtained. So the intention of this is to ensure, I cannot initiate a proceeding for recovery. What can I do? I can only go before the NCLT and make my claim, or I have to go before the liquidator and make my claim. So they are compelled to come to the liquidator. Now what happens is,
under section 53, we call it the waterfall mechanism. Under 53, who is paid first, who is paid second, who is paid third, who is paid fourth, who is paid last. Now this is ranked. If you look at section 53, it is called distribution of assets. So the first one is insolvency resolution process costs and the liquidation costs. Then you have the, I said, security. It is shared equally between the workman and the secured creditor. Then C, you have wages and unpaid dues owed to employees other than workmen. Now I must tell, there is a group of category, there is a group which is called workmen, the other group called employees. Workmen are those who satisfy the criteria of workmen's under the Industrial Disputes Act. Employees do not fall under the category of workmen. Of course, if you want any further clarification, you can raise it. I will quickly clarify what is workman, what is who is an employee. Now, what happens is those persons who are not workmen get it here, and then you have financial debts owed to unsecured creditors. Now, you had secured creditors and workmen taking it equally. Then you had wages and unpaid dues to employees, and you had financial debts. You have financial debts to unsecured creditors, and then now you have the central government, state government, all the other liabilities, all the other charges, probably the electricity, whatever dues are there, all these things you can raise. And then after this, you have remaining debts and dues, preferential shareholders, equity shareholders. So this is how it falls. It falls in this manner. Now, I will look at section 52. 52 is an important provision. I was, in fact, sharing with you a situation where there is a bank. By virtue of Sarfaesi, it has the power to sell its security under section 13(4). It has the power to attach and then sell the property. Now, when it sells the property, as I said, it has to share the 50% of the proceeds. So, in other words, the workmen have pari passu charge on the security that the secured creditor has. So, 50% has to be shared with the workmen. Now let us say here is a situation where the banker says, I will not, I will not enforce my security. I will not enforce my security. In other words, I will not sell it. I will give it to the liquidator. Let him sell it and let him distribute it, and I will take whatever comes to my share. The bank can take that stand. He will say, I will fall under 53. So I will take it when the property is sold by the liquidator, and he will give me my share in accordance with section 53. We just now dealt with 53, where I will get 50% and the workman will get 50%. Now, if, let us say, the banker or the financial institution says, I will not, relinquish my security interest to the liquidator, I would prefer to sell it myself, take the sale proceeds and share 50% with and give 50% to the liquidator. So in the second case, he stands outside the liquidation proceedings. He stands outside the liquidation proceedings. He sells, he has to intimate the liquidator. He then auctions the property, gets, let us say, 80 lakhs, shares 40 lakhs with the liquidator. He gives 40 lakhs to the liquidator. And then, let us say, he still has some more money to recover, who the secured creditor, who has already sold the assets. Then he would fall under section 53. He would fall under section 53D, where it says, in the waterfall mechanism, he falls under financial debts owed to unsecured creditors. Then he comes in that category. So under the waterfall mechanism, he receives whatever as a secured creditor. Then he comes to D as unsecured creditor and receives it. So now let's look at the question. Section 52 of the IBC states that secured creditor can have the option to realize security interest outside the liquidation proceedings or choose to relinquish its securities. But under section 33(5), bar to file case and legal proceedings like moratorium, then how can secured creditor enforce? So here, section 33 subsection 5 bars initiating proceedings, bars initiation of proceedings. Fresh proceedings cannot be initiated. Now here, I said 13.2 has been taken. If 13.2 has not been taken, you cannot now initiate 13.2. Let's appreciate the position. Now let me read 33 for further understanding. It's a very important question, very interesting question also. 33, initiation of liquidation. 33, I directly go to subsection 5. Subject to section 52, when a liquidation order has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor. So please understand, let me repeat it. Subject to section 52, we read 52. When a liquidation order has been passed, no suit or other legal proceeding shall be instituted. So the action of a bank or a financial institution initiating action against the secured asset under section 13.4 to attach and sell would not fall under the under section 33.5 because it is accepted, it is exempted, and further it cannot be considered strictly a legal, it cannot be considered a suit, but however it can be considered a legal proceeding. But you see the initial phrase, it says subject to 52, subject to section 52. So an exception is carved out to a secured creditor. So that exception is what becomes important. By virtue of that exception, the secured creditor can take action under section 13.4, but he cannot file a suit. He cannot file an OA under RDB Act. Let us be clear about it. Now, what happens is, even if I have a secured asset, I can go under OA without invoking Sarfaesi. That action cannot be taken. So, I think I made it clear. So the question is, when section 33.5 bars the filing of case and legal proceeding like moratorium, then how can secured creditor enforce his security interest? So there is an exception carved out under section 52. I stand outside the liquidation proceedings, sell the security, share it with the liquidator, and then take my share. And then again fall in line if I have not recovered everything that is due to me. So I hope I've answered. It's a good question. I hope I've answered it.
Yes, sir. More than answered it. It was amazing. Sir, can you share the screen and continue, sir? No?
Okay. Very quickly, in fact, they've asked me to cover security laws, competition laws, labor laws too. For want of time, I can only give you some points there. When you look at competition law, the basic things that you must remember are that the actions should not be anti-competitive. The two companies or two organizations should not come together to have anti-competitive arrangements. And the intention of the legislation is to avoid dominance or monopoly. And what are the gateways? You'll have to look at all these things to ensure that. So I think if you are in a position to read 4 provisions of Competition Act, you are you're almost there. You can at least be confident of answering. Labor laws, I think you must look at Industrial Disputes Act. Who is a workman? Who is not a workman? And what are the benefits that they get? So these are some of the things that you'll have to look at. And security laws, you'll have to look at SEBI. Time, I don't think time would permit, so I would just request you to quickly brush through whatever you have studied in your executive, and also some of the case laws which they have dealt with in the material. But I must say the focus is on IBC and Companies Act. That was the reason why I decided to take it in the beginning, and interpretation of laws. So that is the reason I prefer to take it. Time permitting, we'll look at it.
Okay.
Yeah. Okay, I'll get on to my case laws.
Yes, sir.
The screen. I hope you are in a position to see the screen. Multidisciplinary case studies.
Yes, sir. It is clearly visible, sir.
Okay, multidisciplinary case studies. We just deal with some of the examples. Now, precedents. Article 141 of the Constitution of India. This is a case law which says about consistency in case laws. Now, if you look at the general position of law, writ petitions, there are no restriction on writ petitions. But however, as a matter of self-imposed rule, high courts do not entertain writ petitions if there is an alternative remedy. So that is the general position. Writ petitions are not entertained if there is an alternative remedy. And generally, there should be a consistency, and that is why we have the law of precedence. Article 141 of the Constitution of India deals with precedence. So probably wherever possible, please use it, because you are dealing with a subject which deals with precedence. So you should somewhere mention Article 141 in your answer paper. So the judge would know you know the law. You can also mention these case laws. You can mention Krishna Kumar versus Union of India, which says that the purpose of precedence is to ensure that there is consistency, and that the precedents ensure that settled issues are not disturbed. Now, I was in fact referring to this Whirlpool Corporation versus Registrar of Trademarks, Mumbai, which lays down the situations under which a writ petition can be maintained even if there is an alternative remedy. Now, even if there is an appeal possible from the NCLT order, you can still approach the High Court on a writ petition if the same is violative of principles of natural justice. Now, if hearing is not granted, or there is there is no audio alterum partem, I must be given an opportunity of I must be given notice. Now, let us say summons is not issued to me. Notice is, I do not get the notice, and the matter is heard in my absence. There is breach of principles of natural justice. So notice should be given to me. I must be given the permission. I must be given the opportunity of filing my objections, and I must be heard. I must be given the opportunity of being heard, argued. So if these three things are not there, and in fact, speaking order is one of the principles of natural justice. If the order passed does not have reasons, then it is in violation of principles of natural justice. So these three aspects form natural justice, principles of natural justice. So if the order passed is in breach of the very principles, basic principles of Companies Act, or if it is you're challenging the wires of some legislation, you can prefer a writ petition. Or as I said, if it is in breach of principles of natural justice, or it is breaching your fundamental rights, you can approach the writ court or the High Court. Now, Pankaj Kumar Mishra versus Registrar of Companies. So this one, reasonable opportunity should be given by the tribunal. Ali Baba Nabisha versus Small Farmers Agri Business Consortium. Now, here is a situation where director cannot be held responsible for daily affairs after he resigns from the company. Now, here in this case, if you actually go through, the director resigned in 2010, and in 2018, check bounce complaint is sought to be filed against this director. But if you actually recollect, under the old Companies Act, we could only file Form 32, and it was the responsibility of the company to file to show the resignation of the director. But if the company for some reason did not file it, the notices would be sent to the director even if he had retired long back. So to overcome that, we presently have Form DAR 11 to be filed by the retiring director and Form DAR 12 to be filed by the company. So for some reason, let us say the company does not file Form DAR 12, the director can still go ahead and file Form DAR 11 to intimate the director, to intimate the ROC that he has resigned. So he does not have to face the nuisance of a prosecution in case he has filed DAR 11. So this is the benefit of the of filing the form. As I was discussing, this is the SFIO case. This is Bhushan Steel matter. Dr. Rajesh Kumar Yaduvanshi versus SFIO. Now, this is the person. Dr. Rajesh Kumar was a director, was a nominee director, and he was sought to be summoned by the SFIO. So that is where it was held that he has not played any role. 128, 129 deals with balance sheets or the financial statements. So manipulation of financial statements, fraud, section 447, 448. So nominee director was sought to be impleaded, but there was no specific allegation against him. And it is not the duty of a nominee director to ensure that he looks into the affairs and brings out if there is anything going wrong with the company. He is there to protect the interest of his institution. So the High Court in this case quashed the proceedings as against the nominee director. So he was a nominee director appointed in Bhushan Steel Limited. QVC Exports Private Limited versus Cosmic Ferro Alloys Limited. Nominee director appointed in quasi-partnership can be removed by. Now, generally, if you look at the law, a nominee director is appointed by financial institutions to protect their interest, to ensure that they are aware of whatever is happening in the board, to ensure that they get the first information if something is going wrong in the company. But however, where a nominee director is appointed by one of the groups to ensure that they have a person representing them or there is a person to oversee, removal of such a person cannot be challenged, and a resolution passed in the EGM for removal of a director or nominee director is perfectly valid. But however, what happens is in the case of a nominee director by any other financial institution, let us say KSA, SFC, or, State Financial Corporation, or any other banker or financial institution, they generally have a clause while lending loan that you must provide for a nominee director. And if the nominee director is removed for any reason whatsoever by the company, then the banker or the financial institution would have the right to immediately recall the loan. So generally, that is how they find the appointment of a nominee director. So here, again, a person who is probably heading any other organization cannot be roped in, and his properties cannot be attached while exercising powers under section 337 and 339 of the Companies Act. Now, here was a situation where the personal properties of this person was sought to be attached for offences as against the company, which was held to be not a proper action and was struck down. See, if section 337, 339 deals with fraud by the officers of the company, by the directors of the company, or by any other person who is a designated officer of the company, in such situation, you cannot attach the properties by roping in a person who is the head of some other organization who is otherwise concerned, in the sense by way of a group company or any other subsidiary. You cannot attach his properties. In fact, I must say it relates to this Nirav Modi scam. But however, this person had nothing to do as such. He was only connected as a director. Vijay Godandas versus Union of India. I in fact had a discussion. The High Court jurisdiction is limited to the territorial jurisdiction. I in fact gave the example of Bihar High Court and NCLT at Kolkata passing the order. Or this Siras Mistry case. Now here is a situation where Honorable NCLT. Now here was a situation, facts which say that Siras Mistry was removed from the chairmanship and later from the directorship. Now that was sought to be challenged by Siras Mistry before the NCLT Mumbai. I must say NCLT Mumbai totally leaned in favor of Tata Group and refused to give the interim relief of staying the removal, and subsequent to which the matter was taken to the NCLT. NCLT gave some reliefs, reinstating Mr. Siras Mistry as the chairman and directorship in the company. But however, that was challenged before the Supreme Court. Supreme Court stayed the order of the NCLT, reinstating him as the chairman and director. So this matter, the reason why I wanted to highlight here is, let us appreciate the situation. Of course, we all know it was all out in the paper. We all know that there was a strain in the relationship, and the chairman, they wanted to remove Mr. Siras Mistry from the chairmanship. Now, actually speaking, there is no position as a chairman. There is no statutory position as a chairman. A chairman is a person who chairs the meeting. It could be a board meeting or a general meeting. Generally, the chairman is for a particular meeting, or it could be decided by a resolution that so and so person would be a chairman of the meetings. He is not the chairman of the company. Chairman only connects itself to the meeting. So such being the case, the concept of chairman only is relevant to a meeting. But however, there is no statutory position. But however, a director is a position which is recognized under the Companies Act. But however, the High Court did not give the relief by looking into the entire facts of the case and the facts and circumstances of the case. So actually, whenever you read the case laws, probably another reason why I wanted to highlight this particular case was here is a situation where you had the NCLT, then you had the NCLT, then you have the Supreme Court passing orders. When you read the study material, you may not, on many occasions, understand what happened. What happened in NCLT, what happened in NCLT, the parties get reversed, the appellant becomes the respondent in the Supreme Court, the petitioner before the NCLT becomes the respondent before the Supreme Court. So to understand this, you must have a close reading and you must keep this in mind when you read it, because so that is where you probably read the case law. They say the petitioner herein, so the petitioner here in this case, or they say the appellant herein. Now you have to look at the court or the forum which is hearing this matter. So if it's the Supreme Court, the appellant herein means the appellant there. Probably that person would have been the respondent before the NCLT. So you must look at that closely. If you don't do that, you may misunderstand the case. You may not have, in fact, you may run the risk of wrongly appreciating the case. You may actually run the risk of understanding the case in just the opposite manner. So this has to be kept in mind while reading the case laws. So we look at insolvency law. Moratorium has been, so here, in spite of moratorium, High Court orders sale of certain properties with the corporate debtor. The Supreme Court stays that. So that is where we refer to section 238, which says that it has an overriding effect over all other laws. So when there is a moratorium, all courts, irrespective of which forum, have to respect it and ensure that there are no further matters or proceedings on that front. So that is what is brought out here. Ekcel Metal Processor Limited versus Bentler Trading International GmbH and another. Now, operational creditor, is a German company, and the corporate debtor is an Indian company. The agreement provides for jurisdiction of the German courts, whether the German company can file a petition before the NCLT. Now, the question is whether the German company can file a petition before the NCLT against a corporate debtor, which is an Indian company. Adjudicating authority admitted the application and the said order was challenged. So here, the appellant challenged the said order. If you could look at this context and make out, it is Ekcel Metal Processors Limited, which has challenged the order of the NCLT, and the appeal is dismissed. So the appeal, that is the one that is taken by Ekcel Metal Processors to the Supreme Court, is dismissed. So you must understand the context, how it goes. So Ekcel here is the respondent before the NCLT, before the High Court, before the NCLT, it is the appellant. So you must understand the change in the position, change in the ranks of the parties to understand the case properly. And one more thing, in fact, my colleague points out that the definition of person under the IBC under section 3, subsection 23 defines person to include any other person established by a statute and includes a person resident outside India. So for all purposes, the German company is a person in India, recognized under the IBC. Ahluwalia Contracts India Limited versus Raheja Developers Limited. Operational creditor sent a demand notice to corporate debtor. Corporate debtor initiated arbitration proceedings after the receipt of the corporate or to the demand notice. Petition was rejected on the ground that the arbitration proceeding is pending. Supreme Court held that the existence of a dispute or the suit or arbitration proceeding must be pre-existing, must be before the receipt of the demand notice. Now here, we are strictly looking at section 9 now, and we are looking at the definition of a dispute under the definition, that is 5 section 28, 5 subsection 28. Now, if you look at dispute, no, but even before I go to the definition of dispute, let me bring it out very clearly that the case, the arbitration was filed by the corporate debtor. The corporate debtor had filed the arbitration proceeding, raising a dispute insofar as the supply of materials. So please appreciate, it very well falls within the definition of a dispute. If I may read, dispute, it's covered under section 5, subsection 6. Dispute includes a suit or arbitration proceeding relating to the existence of the amount of debt, the quality of the goods or service, or the breach of representation and warranty. If I may now draw your attention to section 8. Section 8 says, subsection 2, the corporate debtor shall, within a period of 10 days of the receipt of the demand notice or the copy of the invoice mentioned in subsection 1, bring to the notice of the operational creditor existence of a dispute, if any, or record the pendency of a suit or arbitration proceedings filed before the receipt of such notice or invoice in relation to such dispute. So if there is already a pre-existing dispute by way of an arbitration or a suit, then a petition or an application under section 9 cannot be entertained. So that is what is brought out here. JK Jute Mill Mazdoor Morcha versus Jugilal Kamlapat Jute Mills Limited. Now these are all case laws that are discussed in your study material. I've picked and chosen to ensure that you understand the way you will have to analyze these case laws. So you'll have to do the same thing with the entire study material, understand the position of law. Now you may wonder, how is it possible for me to read the entire study material? I would say your mind is capable of capturing the most important point. Each case law has a point. That's it. Now that is elaborated. If you just were to ask me, it is half a sentence reply in respect of each case law. So it is for you to understand the concept. So once you understand the concept, it's all done. So here, this is the case law which dealt with the aspect relating to trade union being categorized or being considered as an operational creditor. Mobilox Innovations Private Limited versus Kirusa Software Private Limited. This is a celebrated case law, so probably you can remember this case law. This was decided by the Supreme Court, which brought out what is a dispute. Now, in fact, this case law gave a clarification on the definition of dispute. Now, I will just bring out the facts of this case. Probably, if you could also understand the facts of this case, please make a note of this. There was this Star TV which came up with a program called Nach Balia, and in that the tabulation of the votes. Now, the winner was decided by the votes that were cast by the viewers, and the viewers who cast the vote, in fact, the votes that were cast by the viewers had to be calculated by Mobilox Innovation. So that work was outsourced was entrusted by Star TV to Mobilox. So Mobilox in turn subcontracted the work to Kirusa Software Private Limited. Now Kirusa Software Private Limited did the work, but what happened was, after the work was done, the program was over or a certain stage was completed, Kirusa Software raised invoices which was not honored by Mobilox Innovations Private Limited. Later, Kirusa Software issued a notice under section 8 and then filed a petition application under section 9 before the NCLT. Based on that, the NCLT held that the NCLT held that there is a dispute and then admitted the petition. And from there, the matter was taken to the NCLT, and the NCLT held that this is not a dispute, this is not a genuine dispute, and as such we cannot entertain this. But let me tell you what was the position. The dispute raised was that Kirusa Software Private Limited leaked some of the information, and that was in breach of some of the terms of contract, and they must have not done some of the things that they did without the permission of Mobilox. As such, Mobilox refused to pay Kirusa Software Private Limited the due. Now, this was a defense which NCLT did not appreciate. NCLT said this is a ground that you are simply creating for the purpose of avoiding payment to Kirusa Software Private Limited. Now, as against and as such, it set aside the admission and allowed the appeal. So, from this order of the NCLT, the matter was again taken by Mobilox to the Supreme Court, and Supreme Court said, you cannot look into the merits or demerits of the dispute. You will have to look at if there is a dispute, appreciate it as it exists. So that is where it laid down what a dispute actually would mean. So it says that if there is a dispute, you are required to look at and see if there is a dispute and not get into the various other nitty-gritties of the dispute. So I'll just read this out. The adjudicating authority to determine whether there is an operational debt exceeding 1 lakh. Now, of course, it is 1 crore. 2, whether the documentary evidence furnished suffice to say that debt is due and payable and has not yet been paid, and whether there is in fact, for the second point, whether there is documentary evidence furnished, we are required to furnish the bank statements or a certificate from the bank that no payment has been has come into the bank account from this particular person. So third point deals with whether there is existence of a dispute between the parties or the record of the pendency of a suit or arbitration proceeding filed before the receipt of the demand notice of the unpaid operational debt in relation to such dispute. So, in fact, the Supreme Court clarified the position of a dispute in this case. Lakshmipat Surana, in fact, this is a recent judgment that came out in March 2021, which was laid down by the Supreme Court, which makes it very clear that Section 18 is applicable to the Section 18 of the Limitation Act is applicable to insolvency proceedings, because there was a situation where in many cases, even the NCLT started holding that Section 18 extension of limitation period is not possible as is contemplated under the Limitation Act. And Section 238A of the IBC Code, which deals with the Limitation Act, is only clarificatory in nature, and it is applicable retrospectively. Now, Asset Reconstruction Company India Limited versus Bishal Jaiswal and another. Now, these are some of the case laws which you may expect. I'm sure you may expect this because it's the latest judgment, and Limitation Act is quite important. 238A is pretty important. So even this Asset Reconstruction Company India, this was quite. This actually created a lot of confusion. The Padma Kumar's case of the NCLT created a lot of confusion when it held that the figures in the balance sheet do not indicate admission of debt or do not indicate acknowledgement of debt. That created a lot of confusion and I must say heartburn, because many of them suffered because of that finding. So this was challenged. The Supreme Court clearly laid down that the Limitation Act under Section 18 is applicable when there is a mention of the liability in the balance sheet, and it need not specifically mention directed to the corporate, the financial creditor. So competition law, this is one of the case laws that is found in the study material. So if there is a situation where banker takes over some other organization, and if it amounts to a situation where it is taking over the particular asset, the question is whether it is violative of the competition law. The answer is, if it cannot be termed as a dominant entity when it acts in accordance with the provision thereof, as it is acting in accordance with the recovery for the purpose of recovery of its funds to mitigate its losses. So as such, Competition Act would not be applicable in a situation where an institution acts under the Sarfaesi Act. And of course, Sarfaesi Act's main objective is to ensure that the amount or money is recovered. So these are some of the laws that are aspects that are considered in the book. MTNL case law, whether non-signate. Now here is a situation where in fact I discussed this case law. You need not look at an arbitration agreement. If there is no MOU or agreement specifically, you are bound by the correspondences and emails. You can look at the correspondences, emails, and then refer the matter to arbitration. Ideally, what happens in the sense, practically what happens is one person is in a great hurry to get the arbitration done, while the other person tries to scuttle it. So the person who tries to scuttle it would say that there is no arbitration agreement. In such situation, if it can be proved to the court that there are correspondences which clearly show that both of them had agreed to arbitrate, then it has to be referred to arbitration. This is dealing with the power of seizure by the police. The question that cropped up was whether there could be seizure of immobile property by the police. The answer was a clear no, because there is no question of seizure of immobile property. There could be seizure only of movable property of goods. Eviction of tenant. Now, whether eviction of tenant is possible if there is a bona fide requirement by the landlord. Now, a defense by the other person, by the tenant, that the landlord has many properties cannot be a ground to deny the eviction or reject the eviction or dismiss the eviction petition. So, irrespective of whether the landlord has many properties or not, he is entitled to get back his property. So it cannot be denied just because he's got other properties. MC Mehta versus Union of India. In fact, MC Mehta is a very famous person who has filed many cases, many PILs to protect the environment. So all his cases mostly relate to environment pollution and environment protection. Now here was a case where the government moved to stage 4, BS Bharat stage 4 in respect of emission tests. And this was challenged by the vehicle manufacturers who were still having stocks of BS3, Bharat stage 3. But however, the whole thing was rejected on the ground that what is important is the air, the clean air, which is a fundamental right of the citizens. So on that ground, the request or the plead, the request of the manufacturers was declined. Now, a situation where the bank clerk had fraudulently withdrawn money from customer's account and was dismissed. It was a situation where the bank withheld the retirement benefits and adjusted to the loss cost. And subsequently, after adjusting, the amount due was paid to him. Now, this was challenged, but it was held that it cannot be, misconduct cannot be condoned. And, the action was justified. The adjustment made by the bank was justified. Now, these are the general interpretation. Now, when you look at interpretation of law, what happens is you will have to go by the general, public policy that exists. Now, if you look at MC Mehta versus Union of India, public policy demand. Now, you are aware that the Supreme Court has held in various cases that the right to clean air is a fundamental right. And as such, that prevails over the right of a particular person who wants to manufacture. Yeah. So I'm back. Any doubts? I think it was quite a long session for you all, and you all patiently sat through my session. If there is any clarification, any discussion, I'm sure I'm open for it.
Yes, sir. So if anyone has any questions, you can ask it in the audio or you can type out your questions. We'll wait for a couple of minutes.
That is fine. Probably till there is some question or some clarification. That is
Ramesh is actually giving a feedback. Very informative sessions. Thank you, Ramesh.
Oh, thank you. Thank you.
So more than a crash course, I really felt, because since I sat through it, it was more like a master class, and it was really amazing, sir. And you
Thank
spoke
you very much.
continuously. That's really amazing. It was more like presenting the case before the judge itself, the way you did it.
Now, I would only say whatever discussions we had today, if that is kept in mind and you work on the same lines, you can appreciate the entire material. You probably sit through a couple of hours or probably 5 hours, 6 hours, 7 hours. You can complete the entire study material, and you have supplementary material as well. You can quickly brush through it, because whatever we have discussed is a concept which I have drawn out from the case laws, and you will have to only explain it. Don't be afraid by looking at the case law. If you can't remember it, don't worry. But you know the law. So you mentioned in a decided case law, it was decided like this. So this is the law. So you can bring it out that way. And if you know the provision, please mention the provision. Just like I said, please remember some of the provisions, 238, section 14, all these are IBC, section 7, section 9, section 10, section 14. So remember these provisions. Remember some provisions of the Litigation Act. So if you can work out that way, I'm sure you will find it very comfortable. I must say, it's also a very important subject. It's a very important subject, and I think that is why they put it as the last subject, to ensure that all your knowledge, theoretical knowledge, is put to test.
Yeah. So for what I would invite all the students is that whatever Vivekananda sir spoke, it is very much practical, and also he told in once or twice about the exams and how you should approach it. I would invite students to look at the principles, concepts, and how the laws are applied. And he also gave a lot of examples from his personal practice also. So those things you can definitely bring it out in the paper. And this is the angle which we wanted, because whatever you do, once you study the book, you won't get this kind of insights. And Vivekananda sir has helped us get these insights.
Yes, sir, I agree with you, sir. Actually, I'm very happy with this session. I want to say thanks to Vivekananda sir. In spite of his busy schedule, he made some time for us and make it more clarity. I got a lot of clarity, though I'm not appearing in this August exams for module 3. It's more like recollecting my memories about IBC and all those things, resolution of corporate disputes papers, and I'll follow all his suggestions and everything. Thank you so much, sir. Vivekananda sir, thanks a lot.
It's my pleasure, madam. So nice of you. Thank you.
Thank
I'm
you
really
lot.
happy that
Alok sir is always supportive to the students. Actually, I'm a housewife with 2 kids. He helped me a lot in gaining my confidence to achieve my passion towards writing exams and becoming qualified. Yes. With Alok sir's support and with all your suggestions, I hope I will definitely clear my exams and I will become qualified peers.
In fact, students like Padma are inspiration to us. So she's married, has 2 small kids, and still studying in the CS professional finals. It's really great.
I think she herself is an inspiration to so many others here.
Exactly.
There's one small question that I can see. Yeah, please, madam.
Actually, here I want to thanks to Alok sir, particularly sir. We were staying in US. We took the decision to relocate to India with only confidence that what I gave to my family is I can definitely clear CS. We can move back to India. With that confidence, we took the decision to relocate to India. I'm very happy for this, and
now that is very great, Padma, because everybody is telling they want to move abroad. Sir. It's so nice and happy to see that you want to relocate to India.
It's a reverse
you already
journey.
Relocated.
Yes, sir. With your support only it happened.
No, that's also your efforts. So, and like Padma, you said, whatever sir told today, it's not that it is only for this subject. You can use this knowledge in any subject or professional, and this applies to all the subjects, and I'm sure you can do well. So
this session is very informative. Thanks a lot, sir. Thanks a lot.
Thanks a lot, Padma. So Shubham says, thank you for the practical insights and making the subject interesting. Okay, thanks a lot, Shubham. Whether authorized representative in COC need to be insolvency professional or person can be other than insolvency professional too?
It is required that an authorized representative be A resolution professional only can become an authorized representative. So whether the question is whether authorized representative in COC needs to be an insolvency professional, or the person can be any other person other than an insolvency professional. No, it is required that an AR, that is an authorized representative, should be a resolution professional.
So there's one more question: whether CA, CS, or CMA as a resolution professional can become resolution applicant because he is not covered disqualification under section 29 of IBC. Whether resolution professional can become resolution applicant.
I don't think there is any restriction, but it is not advisable. 29A basically lays on who cannot be a resolution applicant. But I don't think, not advisable that a resolution professional become a resolution applicant. Not advisable. Because what happens is the interest become at stake.
Yeah. So I think we have answered.
Just one point here. Just one point here. If you look at the IBC, every other provision that has something to do with the resolution professional has a clause that he should not have been disqualified. He is not being barred by the IBBI. Every time there is a statement with regard to his qualification, his misconduct, and his performance. The reason why this is brought out is, if you look at the practicality, if you look at the practical situation, there is a lot of opportunity for misconduct on the part of the RP, and exactly to prevent that, you have all these provisions. So looking at those stringent provisions, under no circumstances would I advise any resolution professional to become a resolution applicant. Not advisable at all.
Yes, sir. So I think we have answered most of the questions, and sir has given a lot of his time, that too on Sunday, where he could have taken rest instead of doing this. So we really want to thank on behalf of Ekcel Academy and all the students for Vivekananda sir for giving this session. And there'll be many more students who will be watching this later in a recorded version. So hundreds of students are going to be benefited, sir. So your time will definitely result in getting good results for students. And we want to thank you again.
I'm really happy that it has been useful. And Alok, I really appreciate your efforts and all the efforts and pain that you've been taking in coming out with these videos for the benefit of the student community as a whole. I really appreciate, and I wish you succeed in all your future endeavors in ensuring that you serve the student community fully.
Sure, sir. We'll definitely need your continuous support, and we'll disturb you again for something in the future where you can give time for us.
Sir, we will get that PPT presentation, sir. That is SARS PPT presentation. We will get it, sir.
Yes, I'll share it with Mr. Alok. You can take it from him.
Yes,
yeah,
sir.
We'll share it with you, Ramesh. We'll definitely share it with you. No problem. And for people who are watching it on YouTube, what you can do is in the description, we have a link. If you register in that link, you'll be able to get the PPT also. So once you register on the link, you just have to give your email ID, and we'll be able to give the recorded version and also the PPT which sir will share with us. So with that, we'll be closing the session. Once again, thanks for all the students for joining, and Vivekananda sir for giving his time. And it was a master class more than a crash course. Even for me, while I watched it, like whatever doubts we had, everything was covered in 2 to 3 hours. And that is the result of 20 plus years experience and the passion for law practice. Thank you very much, sir.
Thank you.
We look forward to
Thank you very much. My pleasure.
You in the future again. Thank you.
Alok, I hope it was informative. I covered what probably you expected. You said there is nothing